Tēnā koutou katoa. Welcome back to the resumption of hearings on the proposed Timaru District Plan, hearing stream D. This morning we have submissions from Transpower first up, and I believe Ms McLeod is joining us online. So. Ms McLeod, are you able to hear us? Promising. Kia ora. Ms McLeod, are you able to hear us?
Yes, I can hear you.
Welcome back to hearings on the proposed Timaru District Plan. You can begin when you're ready. Thank you. And you have a colleague with you.
Yes, thank you for your time today and for accommodating us on Teams. I'm joined by Rebecca Ing from Transpower, who's the technical lead of environmental policy, and she's available to answer any questions that are more appropriately directed to her around Transpower matters. Today I'll confine my comments to the outstanding matters in my evidence, and will firstly note that in her summary statement, Ms White has generally agreed with my evidence that the matters of discretion in the NATC chapter should allow for a consideration of the benefits of activities, and that this is consistent with the NFL and ECO chapters. Turning to my evidence in respect of Transpower's submission seeking additional cross-referencing to the Energy and Infrastructure chapter, Transpower's submission seeks a national grid-specific policy in the Energy and Infrastructure chapter, and as a consequence seeks amendments in the Natural Environment Values chapter to cross-reference that national grid-specific policy. In this regard, I agree with Ms White that if, through hearing E, a national grid-specific policy is recommended, it would be appropriate to revise the cross-references in the Natural Environment Values chapters so that there's no duplication or conflicting policy direction for the national grid. So really this is a matter that turns on where we get to in hearing E, and what I'm suggesting and what Ms White is suggesting is that we really have to wait and see what happens there. And I don't think we can go much further in relation to those submission points today. The key outstanding matter in Transpower's submission for hearing D relates to the way in which the Natural Environment Values chapters provide for the upgrading of the national grid. Transpower's submission seeks various amendments to policies and rules to provide for the upgrading of the national grid. My evidence describes the national environmental standards for electricity transmission activities and the regulatory framework for the operation, maintenance and upgrading of existing national grid transmission lines. And having described that, I conclude that the rules in the proposed district plan are largely irrelevant, and that's because the NESETA, as we call it, provides the rule framework for things like Indigenous vegetation clearance and all other upgrading sort of matters for lines that exist now. For this reason, I conclude that the amendments sought to the various rules in Transpower's submission aren't necessary. In my view, the NESETA has been drafted to trigger the need for resource consent where adverse effects may be significant. While the rules are of limited to no relevance, my evidence highlights that the policies in the Natural Environment Values chapters remain relevant, and that's, when a resource consent is triggered, obviously those the policies and objectives of the district plan become relevant to considering that resource consent application. My evidence at paragraph 40 sets out the provisions and relevant higher order planning instruments that must be given effect to, and notes that with the exception of one policy in the National Policy Statement for Electricity Transmission, minor upgrading and upgrading are not distinguished. For this reason, I do not agree with the Section 42A report that the proposed district plan policy response should be confined to minor upgrading, and consider that this could give rise to a policy gap dealing where the district plan needs to respond to upgrading matters, not just minor upgrading. My evidence highlights that Transpower's submission does not seek to enable all upgrading, rather seeks that upgrading is provided for, and that this is consistent with the higher order planning instruments. I also note that Indigenous vegetation clearance for operation and maintenance of the national grid could, in some circumstances, have greater adverse effects than that associated with upgrading, such that making a distinction in policy may be arbitrary and not aligned with the actual or potential effects of the activity. The NESETA, really through Regulation 30, distinguishes what's minor and permitted versus what triggers the need for a resource consent. In my evidence, I conclude that amendments to policy ECO P2 and NATC P5 are necessary to give effect to those higher order planning instruments and provide an appropriate policy pathway for the upgrading of the national grid. And I think probably just to highlight that Transpower was seeking a policy pathway and a rule framework. I think perhaps that the need to distinguish between upgrading and minor upgrading as addressed by Ms. White is less important when we're not talking about the rules or regulations, but just talking about what the policy directs should happen. And then the NESETA effectively sets out or distinguishes what is minor or permitted versus what would need a resource consent. Now, the last matter I just want to address quickly is the panel's questions to Ms. White yesterday in relation to the MPSIB and the potential for amendments to be made through this process to give effect to that MPS. I just want to quickly highlight that I support Ms. White's position that giving effect to the MPSIB should be through a future process. And in the context of the national grid, the reason I say that is that the MPSIB includes explicit direction that that MPS does not apply to the development, operation, maintenance or upgrading of the national grid. And my concern or caution is that if there's an attempt to give effect to the MPSIB through this process, and that may include amendments to embed the MPSIB effects management hierarchy, this could inadvertently and inappropriately fail to take into account the exclusion of the national grid from the MPSIB and the fact for a more nuanced approach, if you like, to the way in which that's given effect to. That's a brief summary of where my evidence got to. I'm really happy to take any questions.
Thank you, Ms. McLeod. Just on that last point, so you're not suggesting it's a scope issue. You're just suggesting that from a plan preparation, we possibly don't have enough information or detail to ensure that this plan would give effect to all of the MPSIB? I'm not quite sure I understand.
Yeah, okay. Sorry, I hadn't really contemplated it from a scope perspective. I just watched the YouTube of yesterday's hearing, and my concern would be that if you were of a mind to seek to give effect to the MPSIB through this process, and that resulted in some sort of policy direction that embedded the effects management hierarchy from the MPSIB in a way that would inadvertently or consequently apply to the national grid, that would be problematic, because there are, the MPSIB is complex and includes this explicit direction that the national grid is not subject to the provisions of the MPSIB. So if you as a panel were starting to look at giving effect to the MPSIB, it's important that you're mindful that that any of those provisions should not or cannot apply to the national grid.
So the process that we would go through is we first need to determine whether or not this is the time to deal with it, or whether it should wait. we can't ignore it.
No. No.
Yeah. So
Well, perhaps
do you
the
not
point
feel
I'm-
that you could work with Ms. White to ensure that the provisions don't have that impact?
Yeah, of course I could. I guess I just picked up on the comments yesterday and thought it was worthwhile to highlight today that in anything that you might do in your decision making around giving effect to the NPSIB, please be mindful that the National Grid is exempt from that policy direction.
Yeah.
And yeah, I'd welcome the opportunity to work with Ms. White to assist if I can.
Okay. I'll let the other panel members ask questions of you, and then I'll come back to, but thank you.
Morena, Ms McLeod, sorry about the delay there. I just had a mild panic. My microphone did not work immediately. Thanks very much for the summary of your evidence today. I do have a question around the MPSET policy framework in relation to the distinction between upgrade and minor upgrade. So you've summarised for us, and I can see in front of me here that with the exception of one policy, it doesn't make that distinction.
Yes.
So the policy that does make that distinction, that's policy 5.
Yes.
Are you able to provide or offer a view as to why that's the only policy that does make that distinction and how those policies were designed to kind of work and interact together as a package?
That's a good question. The way I see policy 5 is, in terms of the way in which it might be given effect to, is that really drives a permitted activity rule for that minor upgrading type of activities, and you'll see that rule typically come through in the energy infrastructure chapter and network utilities chapter. And I think that's distinct to policy 2, that's a recognise and provide. I see enable as very much driving a permitted activity, whereas recognise and provide could just be a policy response that says, Transpower, these things should be provided for in some way. Certainly enable drives, this should happen, whereas the recognise and provides a less firm direction, if you know what I mean.
Thank you.
That's the way I see it in the context of these provisions. And I'm not suggesting in my evidence that the policy responses in the natural environment values chapters should enable, but I think the policy 2 and the recognise and provide needs to be given some thought.
Thank you for that. And in terms of the implications, if the proposed district plan provisions didn't make that distinction and didn't provide or recognise for that upgrading, what's the practical implication of that from an operational perspective?
Well, firstly, I guess it would be my view that the district plan wouldn't give effect to the MPSET if it didn't do that. But from a practical perspective, if Transpower looking to clear Indigenous vegetation in natural areas, which is the term used in the NESETA, then that would trigger the need for a resource consent, and that resource consent would necessarily be considered against the objectives and policies of the district plan. And to not have a policy pathway there could inhibit or cause some issues for that resource consent that really wouldn't be consistent with or give effect to the MPSCT.
Thank you.
Is that?
Yes,
Yeah.
that's exactly, yeah, thank you very much, that's helpful. In terms of the Ms White's updated recommendation around the benefits provided in her summary statement, she agrees that there should be a separate matter of discretion, and she also suggests that the wording should be consistent with those chapters rather than limiting to regionally significant infrastructure. Do you have any views on that comment that is included in her summary?
My consideration has very much been in relation to those higher order documents and how they apply to the national grid, which is why my suggested amendments are confined in that way. Certainly, if there's a consistency thing within the proposed district plan, or if there are other policy directions that would lend themselves to a consideration of benefits, I see no issue with it being a more broad consideration, particularly in the context of matters of discretion, that it's really just giving decision makers that ability to cast their mind.
Great, thank you. That's very helpful. No further questions.
Kia ora. I have a question in regards to your paragraph 43, where you're talking about Regulation 30 of the NISETA, and it says that those regulations do not permit trimming, felling or moving of any tree or vegetation in relation to the existing transmission line in a natural area. And
Yes.
so I'm trying to understand, if Section 44 RMA says not to conflict with that, then what is the permitted, like in your view, the permitted clearance? Or how do I better understand what that Regulation 30 means, really, is what I'm asking?
Yeah, well, my evidence is that if Transpower need to go and trim vegetation in an area that falls within that definition of natural area, then Regulation 30 applies, and in effect, Transpower would need a resource consent. And what's quite interesting, and we come across this quite often in hearings, often the district plan will be more permissive than the NISETA would be for those type of activities. So the point I'm making is there's a rule that's going to apply to the trimming of vegetation for the operation, maintenance and upgrading of the national grid. And it's quite a stringent rule. And an application would need to be made for a resource consent under that, or it's a regulation under that regulation. So there's no need for provisions, or there ought not to be conflicting provisions in the district plan in that regard.
Great, thank you. That now makes sense to me, and why it sets the context for why the wording in those policies are really important. On the NATC Policy 5, the activities, buildings and structures in the riparian margin, with that particular rule, the reporting officer has recommended amendments so that it includes regionally significant infrastructure. And my understanding from your evidence, and it's paragraph 45, sorry, I should have said that at the outset, is that you're saying that you want a separate subclause there to say the operation, maintenance, repair and upgrade of the national grid.
Mm-hmm.
But my understanding is the national grid is included in the definition of regionally significant infrastructure. So what's the importance of the additional clause that you're asking for?
The distinction is that new clause A relates to maintenance and repair only, whereas clause B relates to operation and upgrade as well. So in giving effect to those higher order provisions, I'm supporting the inclusion of operation and upgrade. It could be achieved another way if you're of a mind to amend clause A to also include operation and upgrade, but that has consequences for those other activities, roads, rail, stock water systems, etc. So my preference was to draft it specific to the national grid because the higher order planning instruments are specific to the national grid.
Right. No, that's really helpful because that was going to be my next question. Why wouldn't you do it that way? and it's because maybe the roading, for example, doesn't have the same higher order kind of planning hierarchy sitting above it as the transmissions lines do.
Yes, and it may do in the RPS, but I was particularly concerned with policy 2 of the MPSET.
Great, that makes perfect sense. And then my other question might not be for you, it might be for, and I'm really sorry, I didn't note the name of the lady who's joining you from Transpower.
Oh.
But,
Rebecca Eng, yeah.
oh yes, that's right, thank you. So you point out in your evidence, and you repeated it again today, about how, from a practical perspective, upgrades maybe have less effects than repairs and maintenance. And I wanted to better understand that, because yesterday we had quite a discussion around, look, what's the difference between a reinstatement or replacement and new, and that was not in regards to transmission lines. We were talking about a rock wear in that instance. So I wanted to know from a Transpower's practical perspective, what does it mean between upgrade, minor upgrade, repairs and maintenance, where the effects could be different?
Thank you, Ms. Eng here. I think a key difference when talking about the vegetation trimming, for example, between versus an upgrade, is an upgrade could involve thermally uprating a line so that it can have more power going through it, but from a visual perspective, in terms of effects, it would appear no different. For example, where in that situation, the function of the line is significantly increased by being able to put more power through it. And then to the example in Ms. McLeod's evidence, a maintenance activity that might be foundation strengthening, for example, so removing or changing or increasing the strength of foundations might involve significant earthworks, which admittedly they would be of a temporary nature, but may appear quite differently to a thermal uprating. And then the same with vegetation trimming, for example, to meet the hazards from trees regulations, where Transpower is required to cut trees to keep safe distances between the conductors and the trees. An activity like that afterwards would appear quite significantly different than the thermal uprating example. So as I understand it, that's the type of distinction that Ms. McLeod's evidence was attempting to point out.
Great, thank you. That's really helpful. I don't have any more questions.
Yes, good morning, Ms. Eng. My question follows on from Commissioner Mackay's, and I'm going to refer to the example you've given in paragraph, or Ms. McLeod's given in her paragraph 43, and it's about upgrading to add conductors or increasing voltage can generate less effects than maintenance work, such as temporary line deviations. What percentage, I don't quite know how to ask this quick, but I'm going to ask it. What percentage of upgrade works would potentially generate less adverse effects than maintenance?
I don't know that I can answer that, I'm afraid.
I'm not even sure if I've asked the right question.
I can find out the answer, though. I wouldn't like to attempt to answer that when you consider there's 11,000 circuit kilometres of assets across the country in all varying terrain and varying requirements in terms of what the maintenance and upgrading activities might be. So I don't think that it would be a straightforward answer to give in a wholesale manner. But I could attempt to find out if you
Yes, please.
if you would like.
Thank you. Yes, please. Thank you. I have no further questions.
Ms McLeod, I have some questions for you in relation to Eco Rule 3. Just picking up on your earlier comments, but I noted that Forest and Bird in their submission were asking for the rule to include only, or a limit to the permitted activity stated to be within 2 metres of the national grid, or well, at that stage it was the national grid, but Ms White's recommending or electricity distribution network as well. I just wondered if you had a comment about that submission point in the context of what you were telling us before about the impact of the MSET requirements.
Yes, I did look at the 2 metres, and I think you had some questions yesterday about how and where that number was arrived
Yes.
at, and I probably had the same questions. My understanding of the work that Transpower does is that 2 metres in many circumstances would be really impractical. Like the limit would be, the standard would be difficult to comply with because of the scale of the structures, you know, in terms of foundation maintenance works on transmission towers, and also if there were vegetation clearance necessary underneath the conductors to achieve compliance with the hazards from trees regulations, that would, the conductor's swing is you know, in wind conditions is significantly more than 2 metres. So my view is if Transpower needed to rely on that rule, the 2 metres would trigger the need for resource consent in most circumstances.
You will have participated, or we know that you've participated in many planning processes throughout the country. From your experience, are there rules in other district plans that require that 2 metre or impose regulation beyond 2 metres?
I think there may be some rules that have some standard similar to that, but I can't off the top of my head think of an example where that standard applied to the national grid. It may be that it applied to the upgrade of access tracks and similar activities. I'm not aware of any standards that I can think of off the top of my head where I've seen that an arbitrary 2 metres established for all works.
Thank you. I also just had a question about fire breaks in the context of national grid infrastructure. Are those works undertaken by Transpower in relation to the protection of any of their infrastructure?
I think that might be another answer that I can add in with the earlier question, because I think that's a matter for the hazards from trees regulations, and I think that there might be provisions in the NES for plantation forestry, if that's the type of issue that you're referring to.
So probably by way of background, there are hazards from trees regulations that require landowners and then Transpower to maintain separation between vegetation and transmission line conductors to prevent any hazards, electrical hazards or fires. And so it's those regulations that drive the need for vegetation to be trimmed as a maintenance activity and operation, I guess, around transmission lines.
But does Transpower undertake that work itself, or is that undertaken by the adjoining landowner, or in the case of forestry?
I think it's a mix, but Transpower service providers carry out a lot of that work.
Right. I was just
as I understand it, the regulations require landowners to do it or Transpower to give a notice for them to do it. And if it's not done by the landowners under the requirements of those regulations, then Transpower will do it themselves.
So if that work was required to be done, are you satisfied that Eco Rule 3 would enable that activity to occur by or on behalf of Transpower?
It would to some extent, but of course, as I've noted earlier, it's more likely that the NESETA provisions would apply.
Okay. So do you think there is still a need for the Eco Rule 3 in the district plan?
Eco Rule 3 would apply if Transpower were to build any new transmission lines, because the NESETA only applies to those lines that existed at a certain date. So anything new that Transpower builds would need to rely on the rules in the district plan. And, you know, often the scope of rules like this applies to other activities, like, for instance, you've mentioned the recommendation to add distribution lines. And so my view is the rule does no harm, and in fact would provide for a situation where new lines were built. But it's been my evidence that the need to amend the rules is somewhat limited because of the presence of the NESETA and the regulations that apply to the maintenance and upgrading of the national grid.
In the context of the rules relating to commercial forestry, Ms White's recommending, in consultation with forestry operators, the inclusion of an advice note is to refer specifically to the national regulations. Is that required, do you think, in this context as well? Or do you think it's sufficiently clear that the two regulatory responses stand alone and that there's no confusion in terms of the drafting of the district plan and its reach?
I think advice notes are useful where there are regulations outside of the district plan that would apply. Yeah, it's helpful to plan users, but I wouldn't say it's a must-have.
Right. Okay. Thank you for that. I don't have any further questions from you. Thank you.
Thank you very much.
Thanks.
Rooney Group Limited, Mr Hall. Thank you.
Good morning and thank you. So I guess in terms of the main sort of submission point that we made in relation to the overlap with district and regional council consenting, that was pretty well sort of canvassed yesterday, and I've listened to some of that, and so I don't disagree that it can be done. It's just a question of whether or not there's a need to. And of course, there's that direction in the regional policy statement that, you know, gives that option for district councils, but doesn't actually require it. So I won't talk to my evidence too much in that regard. But what I thought it might be useful to give you a bit of background in terms of applying for resource consent for gravel extraction, which is largely what Rooney Earthmoving does in the beds of rivers. So resource consents for gravel extraction from the regional council are a discretionary activity, and therefore all effects are able to be considered. And that's one of the reasons why I state in my evidence that Section 6 matters are covered by the Regional Council when they assess a resource consent application. Before an application will be accepted for gravel extraction, gravel availability is required to have been issued by ECAN to accompany the application. And all commercial gravel extraction in South Canterbury is undertaken in accordance with a memorandum of understanding between the South Canterbury Gravel Extractors Group and Environment Canterbury. So that's a slightly different arrangement from the rest of Canterbury, where some long-term consents were surrendered in exchange for this MOU between the contractors and the Regional Council. So the MOU limits the volume and the duration able to be applied for. So the maximum duration is currently 18 months. And that is to promote short-term, low-volume, high-turnover consents to avoid gravel banking and to ensure consents are issued on need in accordance with gravel availability. So included in ECAN's assessment of resource consent, of their assessment of resource consent applications, freshwater ecology, terrestrial ecology, and that includes bat habitat where applicable, cultural impact, location of any temporary stockpiles outside of the bed but within the river margins, the access to the riverbed, and the distance to sensitive activities such as residential activities. The Regional Council also requires the applicant to demonstrate the need for the gravel as part of the application. And interestingly, ECAN recently advised that 61% of river gravel extracted in Canterbury is used on local authority roads. So any increase in consenting costs ends up being passed on to the end user. So Rooney Earthmoving's last two gravel resource consents from Environment Canterbury cost approximately $14,000 and $15,000 each. 2 years ago, the same resource consents were costing approximately $3,500 to $4,000. The Timaru District Council deposit for land use consent applications is currently $1,800, let alone the additional charges for processing. So not only does this additional resource consent, if it's required from the District Council, add cost, it also potentially increases the time taken to obtain resource consent. So processing delays can impact significantly on whether the gravel sought is actually available for the identified project, and avoiding unnecessary duplication is an important factor for an efficient consenting regime. And I guess in terms of my evidence, I've given some examples, or an example of where we have required a resource consent from another local authority, and just the level of duplication that came across. And so what we don't see is any sort of direct benefit into, it certainly seems from my perspective that all the issues are canvassed by the Regional Council when they consider those regional applications. So just in relation to paragraph 31 in my evidence, we're talking about the identification of ECNA solely in the beds of rivers. I have gone back and looked at some of those ECNAs, and I agree with what Mr Harding said yesterday, that they do include the margins, so they're not just confined to the bed. Yeah, so I accept that. That takes me on to the long-tailed bat overlay, and our view is that it is an SNA by definition. I understand the reasons for not wanting to kind of connect it, if you like, in terms of those broader SNAs, but I do think it is slightly misleading with it not being identified as an SNA, because it is for that exact purpose of protecting habitat for significant Indigenous fauna. So we're not opposing the need to protect habitat for bats. It's just the way the layer works and the rules that go with that. And we've raised Ms White's, the point that Ms White has recommended to accept the Director General's submission to extend the bat protection overlay to match the Canterbury Maps overlay, and so we've raised that natural justice issue because it's not just tweaking the layer around the margins, it's actually significantly extending the mapping of that overlay and will catch additional properties. And I've given that example of one of Ronnie Farm's own properties that's caught, but it's far wider than that. I guess, the threshold, so while Eco R4 does provide for some trees to be cleared as a permitted activity, the threshold for those trees that can be cleared is relatively small. So we're talking sort of 10 centimetre diameter for an Indigenous tree, 22 centimetres diameter for an exotic tree other than a willow, and 70 centimetres for a willow. So they could be, that could include things like sycamore or wilding trees that are growing on someone's property that are within the bat protection overlay that need to be cleared. So the way the rules are written at the moment, they would require resource consent. And I guess our submission point is that there needs to be a better permitted activity pathway to enable a property owner to clear those trees if there's a need to, without having to require a resource consent. Because at the end of the day, that really the protection of the bats, or that having that overlay, is there for public good. There's not really a private benefit in that, and I think it is the landowners that are essentially penalised if they were to comply with the rules as they are written. As I've noted at paragraph 40, the minimum cost to apply for a resource consent is $1,800, and so it's difficult in terms of there can be many hundreds of trees on a property, and just how you go about applying to clear those as a permitted activity if needed, or through a resource consent, just how you do that without it costing a lot of money. And I guess Mr. Clayton from the Department of Conservation yesterday, in response to a question, he said willing engagement is key, and so in other words, it's important to have in terms of the outcome that is sought of protecting that habitat for bats, that there's buy-in from the property, from landowners to enable that to occur. Just in regard to Eco R6, which is the boundary adjustment subdivision rule, we've made the submission point on. I don't agree with where Ms White has landed in terms of that needing to be a discretionary activity. We think it should be able to be done as a controlled activity, or certainly a restricted discretionary activity at the very least, where, different story if the boundary adjustment is intersecting an SNA, but I can think of many examples where a property owner might subdivide their land with an adjoining landowner, and there's no effect at all on the SNA. And we accept what Ms White said in relation to natural character, the Rule R9 in relation to boundary adjustments. And the other point we made, which I think was canvassed yesterday, was around providing for quarrying activities in relation to the giving effect to the NPS IB. Yeah, I think that's all I really needed to say.
Mr Hall. Thank you. In relation to the subdivision issue, I see that you've provided some alternative drafting, and that's helpful. Thank you. I just wondered, in terms of your comments around Eco R4, whether you had an alternative drafting of a permitted activity rule that would address your concerns? Or would you be happy to have a go at that?
I'd be happy to have a go at that, yes.
Okay, that would be good. Just see if the panel have questions.
Good morning, Mr Hole. My questions are around these bats. Now, yesterday, I'm not sure if you watched the hearings yesterday, I asked Mr War, was his name, wasn't it, the Batman, around his concerns over, identifying the overlay versus SNA, which is part of your submission. And in your submission, and sorry, I'm just trying to find 26, you talk about, is it 26? Hang on a sec. No, 36, sorry. You talk about the Canterbury Maps layer is significantly more extensive than that identified in the PDP. And I just wondered if you could give me some examples or help the commissioners around that particular property, what impact it would have having that BPA layer over it versus if it was a SNA, because you're saying it's more extensive, but I want to, do you have some examples of what that means?
Yeah, sure. Whether or not it's called an SNA or not, it doesn't. That's just a label, really. But it's the rules that that are important in terms of what it triggers. So, there's two things. One, and it changes. It has the potential to change overall activity status when somebody needs to do something on their property, and that just becomes another rule that is triggered and needs to be considered. And it catches a whole. It just broadens the area in terms of vegetation clearance that potentially it needs to be assessed and triggers the need for a resource consent. So I've given that example of the Rooney Farms property. I could talk about my own property that's affected as well, and so that part of it was covered by the layer in the proposed district plan, but under the Canterbury Maps overlay, the entire property is caught in. So I could go down the whole valley, and there's similar properties, and that's what I mean. It's broadened it out quite significantly. So not disputing that bats aren't there. I agree that they are, but it's just finding a way that enables landowners to still clear vegetation where they need to without having to go through a resource consent process. And because and I've had the benefit of going out with DOC staff, I think it was in 2005, and they trapped bats in our neighbourhood and tagged them. And so what I understand from that is bats are transient, so that they don't all go to one roost at one time. The roosts are a little bit like backpackers, so you might have some bats there one night and more another, and and roosts will come and go, I guess. So it's there's a need for landowners, if they're genuinely interested in complying with the rules in the plan and protecting that habitat, to be able to regularly, pathway to have those trees regularly assessed without it being too onerous in terms of a consenting pathway.
Yes, I just wanted to talk a little bit more about the BAT overlay and how it works. So yesterday, evidence that there was, in the 1990s, 296 trees, and now it's come down to 163 trees. And so understanding, again, like what would be captured by going to the Canterbury maps and why it might be important, it seems the evidence that we received was that these trees are in decline and they need to be identified for the habitat to be maintained. So I think it will be helpful to see some alternative drafting, because I don't know how you actually then protect the areas without actually identifying the areas. How do you see that working?
Yeah, and I think that's the difficulty, is that the area where the bats are present is identified, but of course all the trees where they roost haven't been identified. That work is still being done constantly by the Department of Conservation. And I can speak on my own property again. So last year there was a bat roost tree identified next to the river, and that's now banded and marked. There's other sites on our property where they have been monitoring for bats, so they know there's a lot of bat activity at a particular location, but they haven't actually tracked those bats to a roost. So I think that's the difficulty, is that it's the information is still being gathered all the time in terms of those roost sites.
And I think it was also really helpful for when you did your opening presentation to take us through what a resource consent looked like. And it was also really helpful that you did clarify what you now see Policy 10.3.1 being in the RPS. When you talked about the background, you talked about the new MOU and that people gave up or surrendered their consents. And so I just wanted to know, how does that work? How does that trigger?
So the memorandum of understanding is it's between Environment Canterbury and all the commercial gravel extractors in South Canterbury. So essentially anyone that extracts gravel commercially, and I'm not sure of the exact date that was signed. It's been around for a little while now, but it was to manage gravel better in the South Canterbury rivers, because the South Canterbury rivers are different from some of the larger Canterbury rivers like the Waimakariri, so they don't always carry as much gravel, and so what the MOU did is it just enables those resource consents to be turned. Well, the benefit to the contractors was that they would be turned around very quickly. Still had to have availability confirmed from the engineering division of Environment Canterbury. So we would identify a site where we would like to extract gravel. They send the engineers out, they will assess it, they'll say, yes, there's 2,500 cubic metres there that can be taken at this location. We then use that to submit with their resource consent application. And so that was the benefit of the MOU, is it just, it didn't tie up gravel resources, it enabled it to be spread around between everyone. And you didn't have one contractor sort of tying up a particular site in a river for, say, 10 years. It was open to everyone to access those locations as they needed the gravel for particular projects.
It is really helpful to understand, because I'm often, depending on where you are, you're told there's lots of gravel, we need to get rid of it, and then other places there's not enough, and sometimes the distances apart aren't that much, so that's really helpful to understand. And and what you've just said now explained it to me, because I was thinking, well, what was the benefit for the commercial operators to sign this thing? So really helpful, thank you.
Thanks.
Thank you. In regard to the boundary adjustments, so you initially sought changes to Eco R6 in your evidence, and Ms. White in her summary report has accepted that in part and has agreed, has recommended, I should say, to exclude the application of the rule NFL R9 to boundary adjustments. And then notes that these would be managed as a controlled activity with sub R1. Had you have a chance to look over that?
Yes, and that's fine, we accept that.
You accept that? So is there anything outstanding from your view in relation to what you were seeking in your evidence?
So that doesn't cover SNAs?
Yes,
Yeah, yes.
and that's where the Eco Rule 6 amendment came in. Great, okay, thank you. My other question for you was also in her summary statement. Ms. White did a preliminary high-level look at the Canterbury Land and Water Regional Plan and went through to look at what the controls related to. You did go through what the consenting today looks like, but I wasn't sure if you had kind of gone into the depth here to see what might have been missing from district planning controls. Do you have Ms. White's summary in front of you?
I don't. No,
That's okay. So, so from her reading, the regulations in the Canterbury Land and Water Plan do not appear to manage landscape effects beyond natural character effects of those water bodies identified as high naturalness water bodies. Is that do you have any view there or your understanding or experience with those provisions?
Yeah,
Would that
I
be...
do. So they do, the Regional Council considers all effects, and that is quite a bit broader than just those high naturalness waterways. So we do have to provide an assessment of natural character in the lower catchments as well. So broadly, that is all considered. The only areas that the Regional Council doesn't take into account, and this is where we do find, in that Waimate District example I gave was a good example where one thing triggers a consent, but then you end up having other matters considered, and it almost seems like the main issue that the district councils want to consider, because they don't necessarily have that expertise in terms of the riverbeds, is around transport movements and noise. They're the key kind of district council functions that the regional council doesn't consider. But then in terms of gravel extraction, you're generally doing it in the riverbed, so I'm not ever aware of there being an issue in relation to noise from gravel extraction within a riverbed.
So in terms of the controls relating to biodiversity, Ms. White identified that they appear to only relate to aquatic ecology matters or are limited to restricting excavation within 100 metres or birds nesting or rearing their young. Are you saying that you're confident that the assessment is broader than that?
Yes, absolutely. Yeah,
okay.
all matters are considered.
All matters under the discretionary.
Yes, and that includes terrestrial ecology. Everything. Not just the aquatic ecology, because when so we do the other thing that all gravel extractors in Canterbury do is they work to a code of practice that's been developed by the Regional Council, and so gravel extraction, it's not undertaken in the wet bed of the river, Sometimes you have to put in culverts to get across the braid channels, or a temporary bridge, but it's all done on the dry riverbed, and so that has to be, that is where the effects are. So that is what is considered.
Thank you. And her last comment here is that the regional plan does not identify significant Indigenous vegetation and significant habits of Indigenous fauna. And based on this and noting all the values, that those regulations can't be relied upon to achieve Section 6B, C or Section 31. So your position is that those the plan can be relied upon?
Yes, absolutely. And we are asked questions if we don't provide that information when we submit a resource consent application for those ecological effects and assessments. I've been asked questions from the Regional Council about how, whether or not there has been or for an SNA assessment in terms of the criteria within the RPS. That's really there for district councils to use, but we have still been asked how our proposals fit in terms of that. So yeah, I'm absolutely confident that the Regional Council is considering all those matters when it processes resource consents.
Okay, thank you. That was good just to talk me through that. I appreciate that. Thank you.
Mr. Hull, following on yesterday, we asked Ms. White to do a bit of a gap analysis between the Regional Council planning framework and the district planning framework, and it might be useful for you to be looped into that work as well, given your experience directly with the consent planning process. I think, Ms. White, you had acknowledged that it may be useful for you to make contact with consent processing planner at ECAN, so that could be constructive. So thank you. Thank you for your submission.
Okay, thank you.
Welcome, gentlemen. Just before you begin, I just wanted to note that on Monday, the panel did a number of site visits, a bit of an orientation around the district, and we did visit the mouth of the river and the Huts settlement. So with the assistance of the Matt, it's fresh in our mind, so thank you.
You have my verbal evidence here. My name's Matthew Hall, and I'm making this submission on behalf of the South Rangitata Huts. I'm a member of the New Zealand Order of Merit, and I've been presented with this honour, actually, for service to the environmental advocacy in the Queen's Birthday Honours in June 2018. I've had a number of offices within New Zealand Fish and Game, and was involved in submitting in both the Rakai and Rangitata Conservation Orders. The Rangitata Conservation Order recognises the outstanding national and regional significance of the Rangitata River as a braided river for its ecology, for the salmon fishing, and for recreational values. The South Rangitata Huts are part of the infrastructure attached to the Rangitata River, and for some of us, the value is priceless, and for others perhaps has a market value of between $15 and $20 million. And the replacement value may be nearer $40 million. If somebody asked me where on earth I would want to be, the answer is really quite easy, at my hut at the Rangitata. It's largely where I've lived my life. I have a grandson who's a 6th generation Rangitata fisherman. And young Archie's experienced some pretty serious health issues, which has seen him spend time in the Starship Hospital in Auckland. And he says, "Grandad, the Rangitata's my happy place. It's my sort of environment." He's 8 years old. Between the south and the north huts, there are about 200 huts. All have their own stories and special values. In caring for the needs of people, it's a wonderful resource. The sea and the river brings with it many attributes, adventures and experiences, and at times it's an amazing place to be. That's why it's so special. The Rangitata settlement has survived 120 years, and given a chance it may survive another 120. No one knows. Each day at the Rangitata Reserve is another day to be treasured. The reserve status is gazetted under the Reserves Act 1977 as a reserve for soil conservation, fishing huts and recreation, and vests in the Timaru District Council. The first main statement is the reserve is in a developed state. If you refer to the attached aerial maps that are at the back, you can have a look at them later on, you'll see that it is in a developed state, and the only green spaces are the low-lying areas where you can't build a hut, close to the coastal inundation or coastal erosion line, or in the camping ground, so there's no further room for huts. Back in 2003, when preparing a management plan for the reserve, the Timaru District Council described the reserve as follows. The majority of the South Rangitata Reserve is relatively developed state and meets the needs of users. In the last 20 years, only one new hut has been constructed, and that's to replace a derelict hut. There is only one vacant section at the moment, and that was created because of a fire. And my understanding, the tenant is not able to rebuild. The section remains vacant, with the council suggesting that maybe it can be used as a children's playground. This use was not considered practical by the hut holders, and there are a number of reasons for that. So, other than that, all sites are occupied. I understand rent's been collected by the council for all huts on all hut sites that appear in the photographs. The existence of each hut has been approved by the Timaru District Council or one of its predecessor. I would argue that in today's world, that with technology and mitigating measures, the risks of natural hazard on life and limb actually are far less now than what they were when most huts were first constructed. In the last 100 years, 2 huts have been burnt down, and that's under what you could say old building setback rules, without any loss of an adjacent hut. Thanks to what we have as an on-fire response unit, fire is seen as the biggest risk to property at the Rangitata, and measures have been taken to minimise this risk. What existing use rights under the RMA Section 10 apply, we're not sure, and it would be subject to legal advice if, for example, existing use rights were challenged. I would argue, though, in the first instance, that under the RMA that we have existing use rights. Just now referring to the plan, OSZ-S3 building height restrictions, the reason for a building height restriction of 4 metres in the Holiday Hut area being imposed is obscure. Can't understand why that restriction is there in the plan, especially where some buildings are clearly over 4 metres. It's all fully developed. At the time the huts were built, they were complying, but now years later, they sit in a zone where there is a height restriction. If the reason for the rule is about some hazard mitigation, then you'd think rather than having a 4 metre height rule, then an adaptive management height rule would be a better approach to cater for rising water levels, sewage disposal and drainage. There are a few huts in the lowest lying area that may benefit from raising the floor level, and provision for this possibility in the set of rules would seem to be helpful, rather than a blank 4-metre height restriction that seems to have little relevance to the area. Surface water from time to time can make a brief appearance around a few huts, but it's rare, and it's normally associated with a blocked river mouth, which now is being mitigated by we have a system of mechanically opening the mouth. What happens is that time provides cements around rules, and they can become intractable. This creates a headache for the owners of a non-conforming property. What can and cannot be done? Not only is there the cost of, there is so much uncertainty around consenting and consenting processes. The issue of insurance and replacement cover becomes a problem. If council was considerate towards hut owners, I think a flexible building height rules would be more helpful than a hindrance. And the next area that I want to talk about is building setback rules. A study of the photographs, and you can have a close look at them, would affirm the comments set out in the objectives of the proposed district plan. Holiday Huts Precinct. And it says that there is an informal and ad hoc layout of buildings, in some cases being closer than they would be otherwise in a residential area. And you just need to look at the photographs to know that the saturation point that they are. And just a bit of history, the reserve in the early 1900s was just a paddock, and prospective hut holders simply chose a site of their liking. In those days, the Acclimatisation Society administered the area, and in other paying a peppercorn rent, all occupiers were required was to hold a fishing licence. My grandfather built our hut under those conditions. Fencing was frowned upon, and the only land he actually rented was the bit of land the hut sat on. In the 1950s, the Geraldine County Council took over the management of the reserve, and the demand for sections increased. Huts were squeezed into all open spaces, and if there was the smallest gap, another hut was added. The huts were all consented. They were roughly built in rows, but planning was rudimentary. The objectives was for fishing huts, utilisation of the land, and maximising recreational benefit. Associated risks were simply accepted as inherent in a holiday by the river and the sea. It was as families started to populate the reserve that fencing became necessary to keep the children in. This resulted in sections of all sizes and shapes being created. Hut holders started to lay claim to their patch. The understanding was all huts were a temporary accommodation, and a 180-day rule applied. This rule still applies to the area, and it's in the leases. A few permanent residents were permitted for security reasons. It was in the 1980s, and after much development had taken place, the council decided, hey, we better survey the area and formally established some sections. And speaking with a surveyor who I knew, he confessed he found it impossible to fit all the huts into his survey. There were no building setback rules, nothing was square, nothing was the same, and he did the best he could. Some of the buildings were even over the boundaries that he put in. We were assured by the council at the time that the siting of huts did not matter because they were placed on the reserve before the plan and had precedence over the plan. Now we arrive at today, 40 or 60 years later. The council in their planning, they're far more risk adverse, and that's what you're here for. There are maps where once no maps existed. There's the coastal erosion overlay, there's the sea water inundation overlay, there's the high hazard area overlay, there's the flood assessment overlay, and it's all scary stuff if you're a Rangitata hut owner. Not that in reality the physical presence of risks is actually physically invisibly increased. Climate change is acknowledged with rising sea levels and greater flooding in alpine rivers, such as the Rangitata River. But for us, climate change is not all bad news. Although it seems only the bad news is being mapped. To my knowledge, what has not been mapped is the thousands of tonnes of shingle that's been transported down the Rangitata and out to sea in the December 2019 flood. No one predicted the 40 to 60 metres of additional shingle this added to the protective barrier between the huts and the sea. And I actually have a map here of when I came to the council building in here in 1996 and made a presentation of the plan then. And I have some photographs of what the barrier was like then to what the barrier is like now, and the barrier is greater now than what it was in 1996. Only this week we've had and of course you would have seen maybe the effects of that, a further 900 cubic flood in the Rangitata. You could actually hear the shingle rattling down the riverbed. And what I don't know is how much of anything this will add to the shingle barrier. What I do know is that no one else knows, and it's not measured in any map. If the sea inundated the reserve, there would be no rebuilding. If the coastal eroded the huts away, there would be no rebuilding. In those situations, building setback rules, they'd have no application at all. What I fear is the application of rules associated with the various maps, though, especially building replacement, was not because of a particular hazard. For example, a fire and replacing a derelict hut. I suspect that in the proposed plan, with its maps, they have a sort of a sinister purpose, and gaining consent to build at the South Rangitata Reserve may be difficult under the plan through the application of rules around the maps. But maps aside, you get to the issue of sorting out the building setback rules, OSZ4. You know, what is a road boundary, and are laneways between the huts, are they roads for the purpose of the issue of the setbacks? Because they provide access. Are we only talking about legal roads here? If a laneway was considered a road, some of the existing structures would be on the road, and certainly within a 5 metre limit. The rule talks about 5 metres from all other site boundaries that adjoin any residential residence. The question is, does this have application to a holiday hut zone or not? It talks about a residential zone, it talks about holiday hut zones, and there's some, we're confused. There's a 10 metre setback from all other boundaries that adjoin rural zones. The question is, you know, to the west of the reserve, is it a rural zone? Does that affect some of the huts? And then sort of the catch-all at the end is there's a 1.5 metre from all other site boundaries. And the question is whether this is the only setback rule that applies to the Rangitata. So I'm confused about the setback rules that apply in a holiday hut zone, and how do they fit the building setback rules? How do they fit the existing area, the way it's been built on and approved? And that's going forward. So site coverage is another rule regarding site coverage. Several existing sites would not meet the standard of the maximum building and impermeable surface coverage of 35%, because it was never contemplated, and it was never contemplated when surveying the hut sites. Some huts may meet the 35% rule, but most, I would think, would be greater than 50%. So that they cover most of the sites. A way of handling the problem would be to alter the boundaries, like they're a bit temporary anyway, and that's sort of an afterthought. So site boundaries, 35% rules, it wouldn't work. It doesn't work for what we've got there now. The reserve is a happy place where people can fish, relax and socialise. Sites are largely developed with most owners taking pride in their property. It would be easy to kill the enthusiasm and the investment sort of with a negative approach that planning can give and create hardship under planning rules. The effect would be to the detriment of the reserve. This is why planning rules should be about finding ways that make it possible for people to meet their aspirations. With all due respect, trying to manage the possible effects of all hazards is like trying to predict who's the winning lotto numbers. Until they're drawn, no one really knows what they are. Same as hazards. Most are best managed when there's a degree of certainty with them. Risk management is a shared responsibility that does not rest solely with the council. And you get a feeling in the plan that it's only the council that's got to worry about it. It's the stakeholders who finally make the decision whether to invest or not. It comes at their cost and should be on their call with an indemnity and no kickback to the council. And you find in the leases that we have, the council actually does have an indemnity for what might happen down there. So that's just it. I haven't had the opportunity to present, and that's the presentation in the open spaces zone area anyway.
Thank you. And are you going to come back and talk to us during the natural hazards chapter as well, or is this...
I think we'll see how we go.
Okay.
Yes.
Thank you very much for your presentation. In terms of the photographs that you've got in that bound document, are you okay if we get a copy of those? Perhaps you could give
These ones here you can.
We can have that? Perhaps if we just...
The first photograph here on the top shows the shingle barrier, which today I think is greater than what it was there in 1996.
Yeah.
And the other one shows the erosion line, the actual erosion line. And that photograph you could take today, and it hasn't changed since 1996.
Yeah.
So there's two photos there that may be useful.
Because we can get a copy taken of those and return the original document to you. Thank you. Can I just ask you as well, in terms of the planning framework in the operative plan, the plan that, not this proposed plan, but the existing district plan, does that present the same sort of difficulties for the hut occupants, or is the operative plan about right in your view?
Again, the thing is we don't know. The issue with the rules in a plan is you have to have your hut burnt down before you find out. So what happened is we've had one hut holders had their hut burnt down, and they found, and being 76 and unwell, they found going through the hoops too great in the plan, too great. Now, what I can't tell you is what part of the plan created the problem for that particular hut holder. Right. But they've since relinquished their section because it was too difficult for them to rebuild with the building setback rules and what was applying within the operative plan.
Okay, thank you. Well, it might be an exercise perhaps for Mr. Boys. And apologies if you've already done that somewhere and I haven't picked up on it, but are you able to produce just a brief comparative table between the operative zoning and what's proposed for the panel? That would be great. Thank you. I'll see if the other panel members have questions.
Thank you, Mr. Hall, and your companion. That was a really fascinating presentation. Thank you. It's so useful for us to hear from your experience living there and over generations, and that the history and the context is really, really enjoyable. Thank you, and great that we've been on site and we can visualise some of the aspects you've raised today. So I have a couple of more comments really about some of the concerns you've raised in your evidence and submission. And from reading Mr. Boy's response to your submissions, he has provided some reassurance to the matters that you've raised around existing use. So that he's confirmed that the existing use does apply. And that the new rule framework won't apply to the existing use. So that might provide a little comfort for you.
The issue under the RMA is with existing use rights, really, is where do you bring into the equation natural hazards? A natural hazard, if it's bad enough, can override an existing use right. So we'll be a bit concerned in the plan if just the fact you've got something written on a map that might happen in 200 years, whether that is enough for someone somewhere to think, well, hey, that overrides an existing use right. So with existing use rights, I think it's sort of really a legal argument as much as anything. You know, if it was clear to us that existing use rights applied until a hazard actually took effect, then that would be great. Yeah.
Thank you. And in your submission, you raised the issue around orderly exit, and you queried whether that should be something that's covered in the district plan, in the proposed plan. I was wondering, from your perspective, because we'd clarified with Mr. Boys yesterday that that's a separate process that sits outside the district planning process. Does that align with your understanding of the engagement you might have had with council over the years?
With planning, I think the sands shift. In 1996, we talked about orderly exit, and you know, it was an issue that the council would look at over the intervening period. Well, it's gone from 1996 to 2024, and nothing has happened on orderly exit. So it may sit outside the planning process, but the issue for us is nothing has happened. Right.
Yes, well, we acknowledge that your concern. I guess for our purposes here on this panel, yes, we're not able to address that for you as part of this process.
I can't see how you can. I can't see how you could address it.
Yeah. Okay. Thank you very much.
Yes, I have just a couple of questions. I too found the presentation really helpful. So it was notwithstanding the natural hazards issues when it comes to existing use, Mr. Boys has said there are existing use rights, but we also know that these are, you know, they have to be to the same character and to the same scale as what previously existed. And I was trying to get an understanding of what that might mean for your community, but you've shared some really good photographs here that show there's not a lot of room on each site for bigger homes.
It's not.
Yeah. So looking through the rule framework and the suggestions that Mr. Boys has provided when it comes to the height limit, he's come up with a practical solution to say within the standards actually take into account what height is required to address any types of flood risk. So if that was put in rather than absolute set, would that go some way to help if somebody had to rebuild to replace their existing home or hut?
I think that would go some way, yes, definitely, yes.
Okay, great. My other question was around your submission on Rule 2, which is about community and cultural activities and education facilities, and currently that has a non-complying status, and you were asking for this to be changed to be permitted. And so what I wanted to know, well, what types of community and cultural activities do you see applying or occurring here?
I don't know the scope of that particular, the boundary of that particular rule. But the sorts of things that we have down there is fishing competition. We have a sports day, a New Year's sports day. It's an amazing event. It's an old-fashioned type sports day that that existing hut holders, families that have come down there for years, neighbouring farming people, it can be up to 400 or 500 people there. Now, it's run by the hut holders, and of course there's some fundraising because it helps fund the things that we've done down there, like the fire response unit. We've got safety equipment and other stuff down there that it's helped fund. So I'd hate to think that there's a rule in the district plan that says, well, look, hey, you can't do that sort of thing to better the area. You know, it's within the rules of our society. We're there for the betterment of the area, and so there's sort of a bit of a commercial element, you could say, about that. What we don't want is somebody to come down with a whole heap of motels or you know, that sort of development, but the sort of activity that is attached to a holiday settlement and having lots of fun, you know, we would like to think, well, that's all okay. So really the questions for you is, we're not bound by what you see as rules in the plan.
But that's really helpful, and it reminds me, I think I saw a notice that there's Housey on the 2nd of January.
Yes,
Yep.
there is. My wife calls the Housey.
Okay, great. Well, we talked about coming.
She's done it for 20 years.
I have one just very last question, and that's in regards to the rezoning request for that. My understanding is there's a back section or a back area that's been asked to not be zoned general rural and instead to come into the open space zone, and it wasn't quite clear what parcel of land was intended, what engagement with the landowners occurred, and what activity actually is carried out there at this point in time.
I'm not quite with you there on that particular question. What land do you think we were referring to? Righto. Righto. There's always history about. It's actually not that shape. It actually goes right down to the river. That block that you've got there, it's that block, but it goes right down. Yes, it's gone a bit far. It's gone a bit far. It's 8 hectares there. That we actually lease, the hut holders lease from the regional council. It's reserved land. It's got the same reserve status as the Green Hut Reserve, but it's an area that is an open spaces area that provides a whole heap of activities for hut holders and the general public. It's not limited to just hut holders, but you'll find there's people walk their dogs there. It's got our rubbish and recycling area there. It's got the water reticulation lines run through it to the huts, the power lines run through it to the huts. It's actually sort of integrated with the management of the hut sites. So you'd think it would be zoned the same as the hut sites, because it's got what I would call a complementary use. It can't be built on, but it's under the licence we've actually got a 5-year licence at the moment with the regional council. It's for recreation. Yeah.
So there's no cattle or sheep or it's not farm.
Oh, we did have, about a month ago, we had a neighbouring farmer brought some horses down to keep the grass down, but somebody had a motorbike and was rather loud, and the horses took fright, and the last we saw them was somewhere up near the main road. So I don't even think horses will survive down there. But the answer is no.
On page 3, I'm really interested to know in what circumstances climate change is not bad news.
Right. I've explained where climate change was not bad news in in the actual commentary.
Right.
And
Sorry, I
you'd say
missed-
climate change is all bad news, and one of the things they say in climate change is going to happen is there's going to be a lot more water that's going to fall on the main divide and on the west coast, and our Canterbury rivers are going to be in flood. And of course, what happened in 2019 and knocked out the main road and knocked out the railway line, well, I'm not expecting those sorts of floods, but floods of around 1,000 cubics, which is a substantial flood in the Rangitata, and similar to the one we had a week or so ago. But what those floods do, if they're going to, with climate change, increase in nature, there's going to be more shingle rattling down the Rangitata that's going to create this barrier between the sea and the huts. So one of the worries we had, say, 20 years ago, and it's always there, it's a worry that's always there, is that the sea will inundate across the shingle barrier. But with climate change, if the shingle keeps rattling down the Rangitata and that bank keeps growing, we're actually, at the moment, that bank in the last 4 or 5 years, the accretion has been up between 40 and 60 metres. So it's been significant. So here we have got climate change that perhaps has one little positive effect. Greater floods, more shingle movement down the river.
Would that be not a double-edged sword, though? Because wouldn't that pose a flooding risk?
I think it does pose flooding risk, but not to the huts. The issue with the Rangitata is when it floods, the natural flood flows and the natural river courses actually are over down what they call the Kapuna stream. It breaks the main road, goes down the South Rangitata branch, which is all terraced and goes back into the river. The other branch that it goes down is what they call the Kapuna, and it goes between Clandeboy and it did in the 2019 flood. It went between Clandeboy and the Rangitata, but never got anywhere near the huts. So the huts actually have never been flooded. They've never been flooded by the river. And not only that, is that the river's never come near to flooding them. There's been some mitigation, admittedly, there's been some mitigation done, and that in about the 1960s they put a groin in. And it's not something you probably went and saw on Monday, but they have a groin up that turns the river away. So that's a mitigation measure. But the huts have never been flooded, and I think it would take a lot more water before the huts. Yeah. I think Clandeboy Dairy Factory would just about go underwater before the Rangitata huts would.
Okay, thank you.
Thank you again for your submission. It's been really
Do you mind if Bob might have a question or a comment?
Yeah, hi, I'm Bob Mortimer. I'm chairman of the Hut Holders Association, and I've got 3 or 4 questions here, and it's very interesting. I see Nick's here, the person that wrote those reports, so I'd like to ask him a couple of questions. That the setback rules on the boundaries on what you're allowed to do if something happens to your hut, i.e. it's burnt down by fire, are you allowed to rebuild? What size are you allowed to rebuild? And these are questions by people who are living out at the huts permanently. So what they've done, and there's one person that's living out there now, possibly shouldn't, under the lease conditions he shouldn't, but what he has done, he sold his house and he's put all his resources in buying a batch down the Rangitata River. He's gone and bought himself a nice motorbike, a nice car. He's used all his money and that's all he's got. If his batch was to burn down, I went and did some measurements, he would end up with a batch about twice the size of this table. By the time you take your boundary restrictions and everything like that. And I said to him, that's in the 10-year plan, we have to wait till it comes out. And I find that my own personal experience in Timaru, I had an old house which I took down and I built 2 units and a 3-bedroom townhouse at the back. And the 2 units, part of the 2 units are, one of their walls are right on the boundary. They're about that far away from the fence. So why are the different building requirements from the Rangitata huts to Timaru City? We are, a lot of hut holders out there are ratepayers. They actually live in the Timaru district and they use that for the weekends. So why, if you get a builder to come out and do something, oh yeah, these are what you can do. Well, hang on, what you can do in Timaru, you can't do at the Rangitata Huts. So why the difference?
Look, in the context of this process, we're here to hear the submission on the plan.
Yeah.
We're not going to make any rulings around what existing use
Yeah.
rights. In this process, there's generally not the ability for submitters to question directly other participants in the hearing, including council staff or advisors. We would be the ones that we've listened to what you've said, and it would be our judgment as to whether we would ask a further question.
which is fine.
But my understanding of the question that you've just asked is it goes beyond the matters that you've raised in your submission and the matters that this panel is considering in terms of the framework. We're looking at the open space rule framework that's been proposed by the council and whether or not that's appropriate in the context of all of the legal considerations that we need to have regard to. So I'm not going to allow the question, and I'm not going to answer the question in the context of these proceedings. But, you can contact the council directly if you have those queries.
Thanks.
Thank you.
So, I think Matthew's covered most of the other stuff. There was questions there. And you probably can't answer them. Yeah. No, fair enough.
Yeah, thank you again. It's been a very helpful submission, and it dovetails nicely into what we observed when we visited the area. So thank you.
I thought you might find it refreshing.
We're going to take a 15-minute break and we'll return to hear Forest and Bird. Thank you.
On the video link, Commissioners, I hope you can hear me. Yes, I can hear you well. Thank you. Yeah, thanks for giving me the opportunity to speak today and for making the video link available, which has made it possible. Really, I'm standing in today for my colleague Nikki, who can't attend, but who filed or made the submission on behalf of Forest and Bird. So yesterday I emailed in some speaking notes, which I hope you've
Received them. If you could just take us through them, that would be helpful. Thank you.
Yeah, thank you. I just actually propose just to read through those today, and then I'll try to answer any questions that you may have along the way. So I'd just like to start by saying that Forest and Bird supports the good work that has been done so far to identify and schedule SNAs in the district, and we would like to see this work completed. Mike Harding, the ecologist, I'm sure you're aware, who's been instructed by the council, notes in his ecology report that limited resources have meant that some lower priority sites have not been surveyed, and that some of these may support significant indigenous vegetation and habitat. And Mr. Harding also notes that access to all of the high country properties in the upper Rangitata River Valley was declined, and that this is a part of the Timaru district that is likely to have important biodiversity values, particularly in naturally uncommon ecosystems, glacial ecosystem derived landforms such as moraines, outwash terraces and wetlands. And Mr. Harding considers that it's very likely that there would be additional SNAs in the upper Rangitata. So we do think it's important that the work to identify SNAs continues, and we'd like to see some policy support for that in the plan. So I'm just going through the key points here, Commissioners, and then there'll be some more detailed points on particular policies that follow. But in general terms, Forest and Bird is supportive of the new policies EcoPX to EcoPZ that have been recommended in the Section 42A report. And in terms of EcoPX, which is the policy to maintain Indigenous biodiversity, Forest and Bird supports the reasoning provided by Mr. Harding in his ecology report, and that reasoning is also reproduced in the Section 42A report. It's essential that the plan includes an effective framework to support the maintenance of Indigenous biodiversity across the district, as well as the protection of SNAs. And Forest and Bird considers that EcoPX, together with the recommended new permitted activity rule, Eco Rule 1.4, which relates to that policy, is an important step in the right direction. The proviso to that is that Forest and Bird does maintain that it would be more efficient and effective if those policies and rules could be combined with the mapping of areas of fully converted or developed land. And this would enable appropriate activities to be enabled and encouraged within these developed areas, while also limiting and discouraging the new conversion of land that's likely to hold Indigenous biodiversity values. In relation to the BATS provisions in the plan, Forest and Bird supports the protection that's included in the plan. However, we do have some remaining concerns which relate to bat habitat outside the proposed overlay. Forest and Bird doesn't consider the bat habitat mapping to be complete, and to the need for a suitably qualified person to carry out the bat monitoring. But turning to the more specific provisions, if I may, starting with the Ecosystems and Indigenous Biodiversity chapter, we support the recommended changes to the introduction, which are broadly consistent with our submissions, and similarly support the recommended changes to Objective 1. In relation to Policy 2, which is the appropriate Indigenous vegetation clearance in significant natural areas, I should start by saying that in general terms, we agree that farmers should be able to continue to farm their land, particularly areas of improved pasture, but we also need to be aware of the Indigenous biodiversity values that also exist in areas of improved pasture, particularly in areas such as the Upper Rangitata, and those values also need to be protected. So there's a difficult balance to be found, and essentially I think the concerns arise where there's changes in land use, which can include changes in farming practice. So we have concerns about the proposed changes to EcoP2, noting that Mr. Harding has supported a limited exception for grazing areas of improved pasture within SNAs. Of course, we're talking about just within the scheduled SNAs here. However, the recommended wording in EcoP2, which would permit ongoing farming practices and clearance arising from grazing, potentially provides for a wider exception than that which was proposed by Mr. Harding. And paragraph 9 of the speaking notes, I've just set out the paragraphs in Mr. Harding's report where he addresses this subject, noting that he talks about grazing at the same frequency, intensity and scale, and also talks about risks that might be posed by changes such as changing from sheep grazing to cattle or deer grazing, which may result in the clearance of Indigenous vegetation. So those are matters which we would like to see addressed in the plan. And we consider that it would be appropriate to include wording, I'm at paragraph 10 now, in EcoP2, indicating that within SNAs, it's grazing at the same frequency, intensity and scale that's permitted, on the basis that this is unlikely to have adverse effects on the existing values of the SNA. Similarly, Forest and Bird considers that the recommended wording in EcoP2 in relation to the operation or maintenance of the electricity distribution network and rail network is not appropriate. The National Policy Statement on Electricity Transmission supports a different approach with respect to national grid activities. However, the rest of the electricity distribution network needs to be managed in accordance with the NPSIB in terms of its adverse effects on SNAs. So there's no higher order policy provisions which justify a different approach for electricity transmission, which is not the national grid. So that would fall under the more general infrastructure considerations. In particular, you'd be looking at whether we're talking about regionally or nationally significant infrastructure and things like that. Paragraph 12, policy EcoP2, as recommended in the Section 42A report, would enable the clearance of SNAs for the operational maintenance of the electricity distribution network without any reference to regionally significant infrastructure or the effects management hierarchy. And this policy would therefore not give effect to the NPSIB and would be inconsistent with Section 6C of the Act, which includes the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna as a matter of national importance. We're especially concerned about how extensively the operation of the electricity distribution network could be interpreted, for example, potentially allowing clearance within SNAs for new transmission lines. More limited wording, for example, referring to trimming for the purposes of maintenance, could be more appropriate. So yeah, concern there around the wording and definition, understanding of interpretation of operation. In EcoP3, the protection of Indigenous biodiversity in sensitive areas, Forest and Bird submission was that sensitive areas should also include areas dominated by native vegetation and areas with a community of threatened Indigenous species. The Section 42A report considers that this submission has been addressed by recommended policy EcoRX, which is policy on maintaining Indigenous vegetation, and the associated rule Eco R1.4, which I've mentioned just before. It's correct that areas dominated by native vegetation and areas with a community of threatened Indigenous species are both potentially captured by the recommended matters of discretion in the rule. However, we consider that these areas should nonetheless be included as sensitive areas in EcoP3. There are areas within which Indigenous biodiversity should be protected, and including them in EcoP3 would provide appropriate further policy guidance for relevant restricted discretionary activities under Eco Rule 1.4. And there's a further submission there, Commissioners, that lake margins should be included as well as riparian margins. And this is arises under the natural character provisions as well, but I think it's relevant in this context. Under EcoP4, this is moving on to protection for long-tailed bats. Forest and Bird remains in support of policies and rules aimed at protecting long-tailed bats. There's still a limited understanding of the location and extent of bat habitat within the district, and the proposed plan framework could be improved by including the ability to increase the bat protection overlay as the understanding of long-tailed bats and their extent in the district increases. The Section 42A report recommends that expanding the overlay should only happen as part of a Schedule 1 process. However, the barrier to this approach is that substantial resources would be needed to carry out a Schedule 1 process. And if important habitat for long-tailed bats is identified outside of the overlay, then it should be possible to recognise and maintain this habitat in an appropriate way without the need for a further plan change. So we'd like to see some provisions which would allow for that. Under EcoP5, the protection of significant natural areas, Forest and Bird supports the recommended approach with respect to the coastal environment, which is consistent with the coastal policy statement. We still have substantial concerns around EcoP5, but these relate to the definition of regionally significant infrastructure and the reference to EIP2, and it's understood that these concerns will need to be addressed at the EI hearing, which is scheduled for next year. In relation to policy PX, which is the new proposed or recommended policy for maintaining Indigenous biodiversity, Forest and Bird supports the inclusion of a policy directed toward the maintenance of Indigenous biodiversity, noting that this is also supported by the expert ecological evidence of Mr. Harding. And as I've mentioned before in the key points at the start of this presentation, we do maintain, though, that it would be more effective and efficient if accompanied by mapping of areas of fully converted land, which would make it simpler to enable activities with no more than minor adverse effects on Indigenous biodiversity values. Moving on to the rules, Forest and Bird supports generally the recommended changes across the rules to refer to the coastal environment rather than to within 20 metres of mean high water springs. Under Eco Rule 1, we note that Eco Rule 1.1 applies within SNAs, and this contains the PER6, which provides for grazing that is not overgrazing or trampling within areas of improved pasture. Noting here, and this is the point I also made at the start, that Mr. Harding also refers to the potential for a change in grazing activity, such as from sheep to cattle or deer grazing, to result in the clearance of Indigenous vegetation, which is particularly important, of course, in the context of SNAs. Forest and Bird wants farmers to be able to continue farming in areas of improved pasture, of course, that have been scheduled as SNAs, so long as the values of the SNA can be protected. I've noted there that there appears to be a typo in the wording. This may have been picked up already, of recommended PER6, which should probably read the clearance is caused by grazing or is due to grazing. As I've already mentioned, Forest and Bird's concern is that this wording doesn't refer to changes in grazing activity, which may potentially have adverse effects on an SNA. And also noting, Commissioners, that Eco Rule 1.2 applies in sensitive areas that are not scheduled SNAs. And the suggestion here is that the provision for clearance within an area of improved pasture in such areas should also include the overgrazing or trampling limitation. In relation to Eco R3, The Section 42A report has recommended including the entire electricity distribution network in Eco R3, and as already mentioned, we don't support this approach, noting that the different treatment for the national grid relies on the National Policy Statement for Electricity Transmission, and that there's no similar justification for including the entire electricity distribution network along with the national grid. Eco R4 deals with clearance of trees in the long-tailed bat habitat protection area. Here we consider that the use of automatic bat monitors would only be appropriate where the assessment is carried out by a suitably qualified person. That doesn't currently seem to be provided for in the plan. And that I've noted there that would be supported by the submissions and reasoning, which is actually included in the Section 42A report. So I'm not sure if that was intended to be included, but it would be sensible to make sure that the person who's using a bat monitor, or at least interpreting the results, is a suitably qualified person. Forest and Bird would also prefer this rule to apply to all potential bat habitat in the district. The proposed overlay provides a good starting point, but as noted above, it's likely that important areas of bat habitat have not been included in the overlay. And Forest and Bird considers that assessments would be appropriate outside the overlay before potential bat habitat is removed. So noting that bats can also live in old exotic trees and that really little is, we don't have a full understanding yet of the extent of the bat habitat. So it would be good to see provisions in the plan which recognise that fact and allow or provide for assessments outside of the overlay where it's likely that bats would be affected. Eco R5, this is earthworks within an SNA. Forest and Bird understands the need to provide for the repair and maintenance of existing infrastructure. However, because of the risk of adverse effects on SNAs, Forest and Bird considers that tighter wording of the rule would be appropriate. For example, Rule 5 could apply where earthworks are required for the purpose of maintenance, repair or replacement of existing lawfully established infrastructure. And this would also help to ensure consistency with the natural character rules, which do use the word required in relation to earthworks in a similar context. Right, so moving on then to the natural character provisions. Forest and Bird maintains its submission that lake margins should be included in Objective 1. We've also requested a policy to support continuing work to identify further high naturalness water bodies. So we maintain that submission and ask for that to be considered. Similar point in relation to policy 2, where we maintain that lake margins should be included. Under policy 4, Forest and Bird maintains its submission that minimising adverse effects does not give effect to Section 6A of the RMA, which requires the relevant values to be protected as a matter of national importance. And we note that the changes recommended in the Section 42A report would further weaken policy 4 by altering clause 1 by replacing the word possible with practical. So noting here that practicability will refer to the circumstances of the applicant as well, and this could include their financial resources, for example, and especially when combined with a requirement only to minimise, this policy wording is not likely to be effective in protecting the relevant values. Finally, in relation to the rules, I've just noted there Rule 3, which relates to earthworks, and Forest and Bird maintains that PER3, which permits earthworks for a 3-metre wide track, is too permissive. In the context of water body margins, the spatial limits should relate to the width of the margin in which the activity is to occur. The Section 42A report also recommends extending PER4 to include all regionally significant infrastructure, not just the national grid. And if all regionally significant infrastructure is to be included, which we don't support, this would make it even more important to include spatial limits. And again, these should relate to the width of the margin in which the activity is to occur. And finally, in circumstances where proposed earthworks are substantial and would have significant adverse effects on the riparian margins of a high naturalness water body, this refers to Rule 3.2, it would be appropriate for council to be able to manage these adverse effects through a consenting process. Thank you for giving me the opportunity to present these submissions, and I'm happy to try to answer any questions that you may have.
Thank you, Mr. Williams. Can you just remind me your role at Forest and Bird? Are you?
Oh, sorry. Perhaps I should have. I should really have introduced myself more clearly at the start. I'm a lawyer with Forest and Bird. Yeah, and I'm presenting this.
Sorry, did you say you
these
are
aren't intended to be legal submissions as such. Sorry.
Oh, sorry, you're a lawyer. Is that what you said?
Yes, a lawyer.
Oh, thank you. Just putting your legal skills to good use, just taking up on the last point that you made regarding the NATC Rule R3 earthworks, you're suggesting that the 3-metre wide track is too permissive, and then you make a submission of how the rule might be framed. Are you able to give us a drafting of a proposed alternative? You don't have to do that now. I'm happy for you to come back in writing, but...
I can certainly try, yes.
Okay. That
I'll
would
make
be...
a note, and if you'd be happy for that to be sent in afterwards, I would like to try and sort of do that.
The practice that we've been adopting is after each hearing stage, we'll issue a minute with some record of where we've requested further assistance, either from the council or specific submitters. So you'll appear on a list, and we'll give you a time frame within which to respond.
Very good, thank you. And we
Thanks.
do have a in-house planner who may also be able to help with that, if that's okay.
Thank you.
Yeah.
Yeah. Also, just I note in terms of the Eco Rule R3 in relation to the National Grid or Electricity Distribution Network, in Forest and Bird's written submission, you had asked for a limitation in that rule to within 2 metres of that work. And we've been trying to unpack in the context of this hearing where the 2 metres might have been derived from. Are you able to shed any light on that? Why 2 metres?
Yeah, why 2 metres? So let me just check again, which rule are we talking about? Was it Eco R3?
R3, and your written, the submission that you filed, your originating submission.
Yes. I know, I can see that, the 2 metre threshold is also appears elsewhere in the notified version. For example, in Eco R1, I think there is a 2 metre threshold. It's also one that we do see elsewhere in other district plans. I'm not sure what the genesis of the 2 metres ultimately is, but I think it's a sort of a practical compromise, I suppose. It's perhaps something to do with the width of a machinery or that's needed.
We would, just trying to identify whether there was any specific evidential basis that supported that as an option over and above 3 metres or 4 metres or no restriction. Yeah.
No, we haven't produced any sort of evidence to support that. No, I think.
No, that's fine. Thank you. I'll see if the other commissioners have questions for you.
Thank you, Mr. Williams, and thank you for stepping in. I appreciate it's always a challenging task to step in and in replace of someone, so thank you for that. So my question, there are a few comments in your summary around the mapping of converted land, and that would achieve a better efficiency and more effectiveness. My question is your understanding of what that task, the scale and magnitude of that task within the district, within and across the district, and the resourcing that might require, and just how efficient that might be. Is that a big task, do you think?
I think I'm probably not the best person to answer that. My understanding is that sort of work has been ongoing for some time now, and that quite often it can be done, at least initially, as a sort of a desktop exercise. There's very good satellite imagery available these days. And it is possible, as I understand it, generally speaking, to identify cultivated areas, irrigated areas, using that imagery, which certainly makes the process a lot easier. And my own understanding is that work has been ongoing to sort of try to map these areas. I'm not sure what stage that's reached or the kind of extent of work that would be needed for the council to complete that.
Thank you.
But it would be very helpful in my
Yes.
submission.
Thank you. At paragraph 10 of your summary, where you're outlining that your preference for the wording in Eco P2, my question relates to the wording that you're requesting. Is that not represented in the associated rule that policy supports?
Right.
In terms of limiting it to grazing that is not overgrazing and trampling?
Overgrazing and trampling. The concern was that I think if you had an area that is at the moment sort of being sort of subject to extensive sheep grazing, and then that changed to cattle or deer grazing, that could have adverse effects, even without it going to the extent of being overgrazing or trampling.
Thank you. That
So
clarifies
it's a sort of essentially a change in kind of a change in land use, although of course not really a change in land use because it's still farming and grazing. It's, as I understand it, this is a difficult issue across, particularly in the high country, where quite significant Indigenous biodiversity values coexist with farming and have done for many years. But there are real pressures associated with intensification of the farming land use.
Thank you. That's clarified my question. No further questions from me.
Kia ora. I actually had some pre-prepared questions that were more around your submissions on the hazardous substances chapter, but you haven't actually touched on that.
I haven't touched on that, no.
So look, potentially you might not have, since you're stepping in for Nikki, you might not have covered that. So let me just come back then to just your submission, your speaking notes. I have a question on paragraph 16, and I'm trying to understand what you mean by include. So the new rule 1.4 is for all other areas, and then you're saying that you consider that it should be included in, these other areas should be included in the Eco P3 sensitive area. Mm-hmm. How do you see that as working?
I think that it would be, so we look at Eco R 1.4. So this is So essentially, when you, I suppose it may need, the matters of discretion may need to be changed as well, just to refer to Eco P3 where it's relevant. So, you know, that the fact that the area that's going to be affected is classed as a sensitive area in Eco P3, that would then be a matter to be considered when it comes to the clearance of Indigenous vegetation in that area. So you'd look at Eco P3, I suppose, as well as the matters of discretion that are referred to in Rule 1.4. So, you know, there would essentially be so Eco P3 talks about you know, protecting Indigenous biodiversity by managing the clearance of Indigenous vegetation in the following sensitive areas. I think it would just give, you know, some extra policy support for protecting these areas of that are dominated by native vegetation, or that include a community of threatened Indigenous species outside the coastal environment. Yeah, so it would essentially give some added protection to those areas when it comes to applications to clear vegetation. Does that make?
I think I'm probably going to have to go away and look at it a bit further to see if I understand how it might work, but thank you. My other question was on paragraph 19, and it's where you talk about the bat protection area, and you're saying there should be a process outside of a Schedule 1 process. So what process, if this is going to impact on you know, landowners and members of the community, what process is appropriate outside of a Schedule 1 process?
Yeah, it's a good question, and we've not, I'm conscious that we've not presented sort of detailed provisions that would achieve this, but I suppose the basic point is that if bat habitat is identified as, you know, perhaps through a consenting process, perhaps the most likely way that the council would become aware of bat habitat, and then that habitat would then enjoy some protection under the plan, rather even if it's not within the overlay.
So similar to the new 1.4 rule for identification of Indigenous biodiversity?
Yes.
Okay. Thank you. So I won't ask, that's it, actually. I won't ask my questions on hazardous. It's all good. Thank you.
Okay, thank you.
Commissioner Scott here. I just have a couple of questions for you. A similar question I asked Mr. Clayton yesterday at DOC around mapping of SNAs. Whilst on one hand, both Forest and Bird, and DOC have commended the council on their mapping of SNAs, there is apparent there's still more work to be done. And my question to you, and it may not be one that you could answer, but what are your views around engagement of landowners? Because I'm sure, but correct me if I'm wrong, there will be no council in New Zealand that has mapped every single SNA. So what are your views and on how to engage to continue to map if we're now down to low priority sites?
Well, that's, okay, perhaps my personal views to some extent are that as these provisions bed in, one would hope that the sort of fears of landowners perhaps around SNAs start to diminish, and there's a more a shift towards sort of more general acceptance and support for these kind of provisions. And I mean, my understanding is that in sort of Timaru district, there has been a lot of landowner support for SNAs, although of course there is still some resistance. So really, it's, I think, just a matter of recognizing that the process isn't yet complete, and including some provisions within the plan to enable further identification of SNAs as as that becomes possible. So just not drawing a line under it now, recognizing that the process isn't yet complete, and that it's an ongoing process, and that views in the community may also change over time, leading to further potential for identification.
My second question is around the natural character chapter and your persistence to have lake margins remain. It was identified by Ms. White and myself, there are no lakes in our district. And
right.
So I just wondered if you knew that.
I wasn't aware of that. I've taken that from our original submissions.
Yeah.
So apparently that wasn't something that's picked up on. If it's correct that there are no lakes, then
Okay,
that
thank you.
obviously deals with that point.
It's Commissioner Solomon here, and I've just got a couple of questions, and it refers to Ms. Schnoyink's table in the original submission.
Yes.
The definition for Indigenous vegetation, she has suggested an amendment to delete non-vascular plants for mosses and or lichens or fungi. Are they the only non-vascular plants in New Zealand?
I'm afraid you'd have to. I wouldn't like to venture a response on that. I'm sorry. I think I need to check that with an ecologist. Is that I can bring up the original submissions? I should have had them open. But
It's on page 10 of her table.
thank you.
At the top.
Thank you. Okay. Page 10. So, page 10, and
Yes.
I hope I've got the same version here. Which provision are we?
We're talking about the definition for Indigenous
yeah.
vegetation.
Thank you. Oh, yeah, got you. Replace with. Right. Yes. So essentially, the submission is to include lichens and fungi, because the community of vascular plants, mosses and or lichens or fungi. The community of vascular means vascular and non-vascular. Right. I believe that this is a definition of indigenous vegetation which has been approved elsewhere. I would need to check where that the proposed changes to that definition come from. It's likely that Nikki's taken that from perhaps a different plan or case law where that's been recommended as a better definition as a community. So currently, I'm just saying the definition means vascular plants that include species native to the ecological district. Oh no, vascular and non-vascular plants. Yeah.
Do you want to come back to me on that one?
Yes,
I
I
can
was
come
going
back
to
to you on
suggest,
that one.
Mr Williams, we can add that to the list of things. If you could
Yes.
just check what the basis for the
Yes.
changes, that would be helpful.
Yes, I can do that.
And then on the same table, on page 32,
Yep.
I'll just find it myself. You talk about, or Ms Schnoying talks about a perverse outcome that happened in the Waimakariri area district that saw the clearance of hectares of beech forest to make way for a deer farm.
Yes.
And my question is, what provisions do you suggest could be used so similar activities can be avoided?
Well, I think this is addressed potentially by the policy Eco PX,
Sorry, I'll just find that.
which is the maintaining Indigenous biodiversity policy. And then you've got, I think it's the Eco Rule 1.4.
Yeah. Okay, thank you.
Yeah, so that's where we were hoping to have as well reference to areas of predominantly Indigenous vegetation in Eco P3, just to sort of underline the point that those areas should be protected.
Thank you.
Thank you very much for your submission,
Thank you.
Mr Williams.
Thank you.
Thank you. Good morning, Madam Chair and Commissioners. I appear on behalf of Port Blakely Limited as legal counsel. There are 3 witnesses giving evidence today for Port Blakely. Barry White, who is seated next to me. His evidence relates to forestry operations. Melissa Pearson, who is the consultant planner and is joining us by video link, and Zach Robinson, environmental consultant, and is seated next to Mr. White. Port Blakely has filed expert evidence in support of their submission on the proposed plan. In addition, each witness has prepared and filed a summary of evidence. In addition to that, I have filed legal submissions for Port Blakely. I have also prepared a summary of those submissions. If the panel would find it helpful, I will speak to my summary now, or alternatively can answer any questions that you may have.
It would be helpful to speak to your summary now. Thank you.
If I could, I have 10 copies of the summary of my legal submissions that I can give to the hearings administrator for her to distribute. This summary of submissions is presented on behalf of Port Blakely Limited, or Port Blakely. My submissions are confined to the key issue raised by Port Blakely's submissions regarding the relationship between the NESCF and rules in the proposed plan which govern the effects of plantation forestry activities. The issue arises because Port Blakely considers these rules are more stringent than comparable rules in the NESCF. The case for Port Blakely is focused on a narrow but important point regarding the Timaru District Council's Section 32 evaluation. Port Blakely considers that the Section 32 evaluation is deficient because it fails to demonstrate that the more stringent forestry rules in the proposed plan are necessary and justified in the context of the Timaru District. The Section 42A report recognises the deficiency of the Section 32 evaluation and recommends the proposed plan be amended to make it clear to plan users that the NESCF has precedence over the proposed plan rules in relation to plantation forestry operations. Port Blakely supports the Section 42A report's suggested amendments to the proposed plan. In addition, these submissions address the bat habitat protection rules in the proposed plan. Port Blakely considers these rules do not currently align with expert advice about known bat behaviour and methods to identify bat habitat. Port Blakely proposed amendments to these rules to address this concern. I will now move on to paragraph 5, policy objective of the NESCF. Here I quote directly from Ms. Pearson's evidence, where she considers that a key driver for the NESCF, which predates the here she refers to the NESPF, which was passed in 2018, and then that was revised in 2023 to the NESCF. And so this was to address unwarranted variation across regions and districts in the management of plantation forestry under the RMA. This variation was creating significant operational and regulatory uncertainty for the forestry industry and leading to uncertain and inconsistent environmental outcomes. This is reflected in the policy objectives of the NESPF and CF, which is to maintain or improve the environmental outcomes associated with plantation forestry activities nationally, and increase efficiency and certainty in the management of plantation forestry activities. Legal relationship between national environmental standards and district plan rules. District councils are tasked with a wide range of functions, including the requirement to control the use of land in order to maintain Indigenous biodiversity. To undertake these functions, the RMA provides that district councils may create district plans, including district rules, to implement the policies and objectives. Such plans must be prepared by district councils in accordance with their obligations to prepare an evaluation report, otherwise known as the Section 32 report, and councils must have particular regard to that report. The RMA also authorises the Governor-General to make regulations known as National Environmental Standards. In this case, the nature of the NESCF is such that there is considerable potential for duplication, overlap, and conflict between the national standard and the proposed plan rules. The relationship between national environmental standards and rules is governed by Section 43B of the RMA, which relevantly provides that a rule that is more stringent than a national environmental standard will prevail over the standard, but only if the standard expressly says that a rule may be more stringent than it. The RMA also requires that where district councils propose more stringent rules, they must explain why such rules are necessary in the particular circumstances of their district. This requirement is founded in council's duties under Section 32 of the RMA, and specifically Section 32(4), which provides if the proposal will impose a greater or lesser prohibition or restriction on an activity to which a national environmental standard applies, then the existing prohibition or restrictions in that standard, the evaluation report must examine whether that prohibition or restriction is justified in the circumstances of each region or district in which the prohibition or restriction would have effect. In summary, district rules that are more standard than a national environmental standard are allowed, provided that such rules are expressly contemplated by the relevant standard and the District Council has completed an evaluation report under Section 32 RMA. That explains why greater stringency is justified in the particular circumstances of the district. This requirement imposes an important constraint on the power of district councils to promulgate rules that are more stringent than a national environmental standard and supports the hierarchy of planning instruments provided by the RMA. I'll now move on to a recent High Court decision of Ryanair New Zealand Limited and Canterbury Regional Council, which explains how the above provisions apply in practice. The court commented as follows on Section 32(4) at paragraph 135 of the decision. A plain reading of Section 32(4) establishes that there are two parts to it. The first defines when it is engaged, and the second outlines what must be included in the evaluation report when it is engaged. The court looks further into the meaning of Section 32(4). At paragraph 138. Importantly, the examination of whether a proposed restriction is justified must be considered in the circumstances of the region in which it is to have effect. This means that local factors, rather than matters generally of concern at a national level or of concern in other regions or districts, must be examined. In my view, this required the panel to be satisfied that there was good reason arising from the circumstances of the Canterbury region to impose greater restrictions on plantation forestry activities than those that appear in the NESPF. The court also comments on the requirements of Section 32(4) to give reasons and the degree of reasoning and analysis required. At paragraph 145, the panel failed to address whether the stringency proposed was justified in respect of the sediment discharge rule as was required by Section 32(4). There is no reference to any evidence justifying greater stringency in the Canterbury region, and the absence of this, in my view, is fatal. The importance of evidence and reasoning and analysis to justify a departure from the NESCF is discussed in the following paragraphs of the High Court decision. Yeah, that's fine. So I'll now move on to page 5. So the Ryanair decision deals with the management of forestry within the Canterbury region. However, the reasoning approach in this decision is equally applicable to the rules regulating forestry in the Timaru proposed district plan. Ms. Pearson's evidence includes a detailed analysis of the proposed plan provisions and whether the provisions have sufficiently been justified by the relevant Section 32 report, consideration of the Section 42A officer's assessment and how this relates to the relief requested by Port Blakely. In summary, Ms. Pearson makes the key point that the proposed plan failed to properly align with the NESCF, and this failure has resulted in provisions where there is no justification for the provision to be more stringent than the NESCF. The Section 32 evaluation did not carry out a proper Section 32(4) analysis, and a proper assessment as required by Section 32(1)(b) was not carried out, in that there was no consideration of why the proposed plan provisions were a more efficient or effective way to achieve the outcomes sought by Regulation 6 of the NESCF as compared to the equivalent provision in the NESCF. It is noteworthy that the Section 42A report reaches the same or similar conclusion as Ms. Pearson and recommends amendment to the proposed plan to address this problem. In conclusion to this part of my submissions, Port Blakely supports the Section 42A officer recommendations as they address the concerns raised by Ms. Pearson, are consistent with the High Court decision in Ryanair, and achieve the outcomes sought by Port Blakely's submissions. Now, moving on to the bat roost protection rules. The evidence of Mr. Zachary Robinson includes a detailed analysis of the proposed plan rule ECO R4. In summary, Mr. Robinson considers the requirement for an ecologist to carry out a specialist assessment of the tree in question as a matter of discretion within that rule is unnecessary and is not aligned with the Department of Conservation bat roost protocols, and will likely result in unintended consequences where tree removal will not be notified to minimise costs to landowners. The Section 42A report recommends amending the matters of discretion in ECO R4 to include the use of automatic bat monitors and to allow for trees that potentially provide bat habitat to be assessed by someone who is suitably qualified and experienced in identifying bat habitat. Mr. Robinson supports the Section 42A officer recommendations as they align with the DOC protocols and the most current information regarding long-tailed bat habitat. More recently, the Section 42A summary statement at paragraph 10C recommends amending ECO R4 so that it does not refer to automatic bat monitors as previously recommended. The reporting officer relies upon the evidence of Mr. Waugh in support of her conclusions. Mr. Robinson has had a chance to review the Section 42A summary statement and the evidence of Mr. Waugh and supports the issues raised by Mr. Waugh. And furthermore, Mr. Robinson suggests the following amendment to ECO R4 in line with Mr. Waugh's approach. This can be found at the top of page 7 of my submissions, and I'll just take you to paragraph 29 where I've indicated an underlined text in bold a suggested amendment to that part of the rule. In conclusion, the primacy of national environmental standards can only be departed from in limited circumstances, and only where such departure is supported by a robust Section 32 assessment. Section 32(4) performs an important function in the statutory scheme of the RMA by constraining the circumstances when local rules may prevail over national environmental standards. In this way, the primacy of the national instrument is not undermined by unjustified local rules. Overall, there is no merit in making district rules that prevail over the NESCF without proper justification, because doing so results in inconsistency between the districts and regions in New Zealand, which is one of the problems that the NESCF was designed to overcome. That concludes my submissions. If there are any questions,
Thank you very much for that. Look, and it may also be a question for Ms. Pearson to consider, but one of the issues that I was just grappling with was in terms of whether or not the use of an advisory note is the appropriate method in the context of providing for the NESCF in the absence of any rules in the district. plan, or the alternative of whether there should be a permitted activity created which effectively permits that which is permitted by the NESCF. And I just wondered from a legal perspective whether you wanted to add anything to do that, or whether you just leave that to Ms Pearson to respond to.
Thank you, Madam Chair. At this stage, Port Blakely doesn't have a strong view as long as the method chosen will achieve the outcome that Port Blakely is seeking. Using advisory notes or rules within the plan have their pros and cons, and so that needs to be carefully considered. The evidence of the planner, Ms Pearson, supports the officer recommendations for the advice notes, but if the panel were minded to support a rule approach, then Port Blakely are willing to support the drafting of that rule, or perhaps our planner could caucus with the council planner to elaborate on that further. But Ms Pearson has also prepared a response to that question as well.
Thank you very much for that. I'll see if other panel members have questions for you.
I do have a question around the suggested drafting amendment to the BAT monitor, but that might be best delivered to Mr Robinson and Ms Pearson.
Yes, I think so.
Thank you.
I have one question, but before that, I just wanted to say in the original submission, when it walked through the jurisdiction and justification test for the more stringent rules, I found that really helpful. And it seems to me that your legal submissions are here today to give weight to the recommendations of Ms White. And if we were to accept Ms White's recommendations, then my understanding is that the two main issues that are outstanding are the bat protection area, the Rule 4, and also consistency of approach and the high naturalness of the water bodies. And there was just one part that I wasn't sure if it was still outstanding or not, and that's your submissions on the eco policies, P2 and P5. Mm-hmm. And there you also sought for there to be expressly state that the regulations prevail over the district plan. And Ms White's response to that was to say, at a policy level, it's not necessary because it's also, written into that advice note of the rules. So I just wanted to check, is that also accepted? Because I couldn't see where it was expressly accepted.
If we go for the advisory note method, then as a plan user, the rule would not be engaged when they would undertake that activity. So then the policies and the objectives related to that rule would also not be engaged. But then if we were to go for a rule method, then we would have to look at how that works with the policies and objectives as well of that rule. Yeah.
Thank you. You call your first.
So Port Blakely's submissions fall within two broad categories. Those related to the NESCF, which will be addressed through the evidence of Barry and Ms Pearson, and those related to the bat protection rules, which will be addressed by Zachary Robinson. The first witness for Port Blakely is Barry Wells. As mentioned previously, Mr Wells has prepared a summary of his evidence. Would you like to hear his summary, or would you prefer to ask him questions?
Look, we have the time, and I think just the volume of material, the summary would be very helpful. Thank you.
Yeah, thanks for that. Just a slight correction, Sarah Shana. I think I was introduced earlier as Barry White, but it's Wells. I think he's a singer, but that's not me. So, yeah, no, I won't do that. So thanks for letting us present today. Port Blakely are a large-scale, long-term responsible forest company. Nationwide, we've got around 40,000 hectares in the South Island, it's about 33,000 hectares, and in the Timaru district, it's about 7,500 hectares, excuse me. So in the South Island, we operate over 3 regions and 8 districts, and that is exactly why the NES was brought in, because having different rules to cover the same activities and the same effects across an arbitrary territorial boundary just never made sense. So, NES PF was introduced 2018 after a significant amount of work by all parties. It was there to standardise rules, give some certainty, and try to avoid being involved with regulation churn, but we're still working on that one. On average, the NES is a risk-based process, so where there's higher risk, the rules are stricter. But on average, the introduction of the NES resulted in the average sort of rule stringency being increased. But we were okay with that because of the other benefits that having that certainty gave us. So as a result of that, we've brought in different controls in our forest operations. We've renewed policies, we've increased our standards, we've brought in new methods and technology to comply. All these have come at extra cost, but we're in a good position as far as meeting those rules. Timaru District Council compliance staff have never actually come out to our forests to see how effective these rules are. We'd certainly encourage it. Other councils come out, regional councils, but it just sort of adds to the confusion around why additional rules or more stringent rules would be necessary. There's a bit of concern about the potential implications of some of the rules in the proposed plan, just the duplication and additional costs that would be brought in when things are adequately covered by the NES. The Section 42A report largely recommends acceptance of our submission, and we just urge that that's the position that's taken. Overall, we just seek that the proposed plan is revised to include those, so it references the NES CF rather than trying to duplicate that. So, that's me, if there's any questions.
No questions as such. Thank you, Mr. Wells. Not Barry White. I do have various tunes going along in my head now. But thank you. Your evidence was very clear, and I have appreciated the summary today. And it sounds like, from Port Blakely's perspective, that the Section 42A recommendations, subject to the method, have largely been resolved. So thank you very much.
I only have one question, because it seems like there's a high level of agreement and alignment now if we were to adopt those recommendations. But mine was, in your evidence in chief, you have a number of appendices, and one of them is Appendix D, which has a map of Port Blakely activities, and across the Geraldine Forest. Do you have a copy of that map in front of you? It's on page 16 of your appendices.
Yes, yep.
Okay, what I was trying to understand was, so you've got Appendix A is the map, and it highlights the 2 areas of forestry for Port Blakely, and then you come to Appendix D.
Oh, yes, yep.
And that's cutout of A. That's a cutout of A, isn't it?
It's not quite. So Appendix D actually covers property that we've just purchased, which is that fallow land sort of in the middle. So that is slightly different to the Appendix A map.
Okay. Right. So when I'm looking at Appendix D, I was trying to understand what activities are actually happening butting up against the SNA areas that are identified here.
Right, yeah.
And so there seemed to be majority plantation forest, but only one area that it had fallow land, and then there's native bush.
Yep.
So I wanted to just understand what is the impact on SNA, what is the difference between a plantation forest abutting it or fallow land abutting it, and is there any difference?
Yeah, no. So apologies, that's probably just too much information on the map, really. But the whole area is plantation forest. We call fallow land the land that has been clear-felled but not yet replanted. So that's like a 18-month window before the trees get put back in the ground, or a maximum of 18 months. So yeah, the fallow land just refers to land that hasn't been planted yet, but will be. Yep. Thank you.
And I have no questions for you. Thank you very much, Mr. Wells.
Thank you, Madam Chair. We'll now move on to our second witness, Ms. Pearson.
Just checking everyone can hear me all right in the room.
You speak up a little bit.
Speak up. Speak up a bit.
Yes, please.
Is that sufficiently loud enough? As with the other witnesses, I am in the hands of the panel as to whether or not you would like me to take you through my summary of evidence or whether you would like to launch straight into questions.
Look, as we've indicated, that we appreciate there is a large degree of agreement, but if you could just highlight anything in your summary that you consider is not quite resolved, and then I would quite like to explore your thoughts on the method, if that's all right with you. Thank you.
Absolutely. I think Shona has summarised the background really well, so I will probably just take you through. I am largely in agreement with Ms. White in terms of the recommendations. The approach to the advice note versus potential rule drafting. The reason I was supportive of the advice note approach from a plan alignment perspective is that it's quite clean in that it is very clear through the use of that note that there are no provisions in the eco chapter or the natural character chapter that apply to plantation forestry. I can appreciate that there is sometimes a bit of concern that advice notes aren't that strong, they don't have legal weight, but in the case of the NESCF, those regulations exist almost regardless of what the plan says. So really the advice note is acting as a signpost to send plan users to the correct place to find the rules. It's not like the advice note is doing the heavy lifting in terms of trying to act like a rule or be a rule. It doesn't have to do that. The NESCF regulations exist, so it is just a direction to take the plan user to the correct place. In terms of the sort of implementation guidance that came out from the Ministry for the Environment on how you would do plan alignment, using advice notes was one of the options that was there. The other option that could be acceptable that I could also work with from a drafting perspective is not necessarily what Port Blakely put in their original submission, which I'll be very clear, I was not the author of the original submission. I've been brought in at this stage to work through the hearing evidence, but rather than create a per standard to expressly talk about plantation forestry, it could simply be a statement that says this rule does not apply to. So you could effectively use the same wording, take out the words advice note and have a statement in there. And that is something else that I've seen working in other district plans to be clear, almost like ring fencing the scope of the rule. So it still sits within the rule, still has the same status as the rule, but it's not a per standard that you have to comply with. So then you can move away from that potential risk of conflict or duplication with the NESCF that you don't want to get, that you don't want to have. So I hope that covers off the the advice note.
That
rule
seems
drafting.
a practical alternative that we can consider, and that wouldn't necessarily mean it needs to then have an objective or policy to support it. And I thought that was a valid point made. You don't want to sort of create an unintended consequence by addressing it in one part of the plan and then trying to not to exclude it in another. In terms of it, I just wondered also whether there was some merit in covering off in terms of how the plan works in the introductory sort of part to make it clear. And it may be that this applies not just to this NES, but also to the other standards, national direction that we're dealing with, you know, just again as a signpost to make it clear that the reach of the national environment standards versus what's addressed in the district plan.
I agree it would be an issue that's wider than just the NESCF. It would be equally applicable to explaining how it works with the NES for contaminated land, NES for telco. They're the same family, and it may be something that the reporting officers wish to look at collectively to say, have we got the signposting correct for the relationship between those national environmental standards and the provisions in the PDP?
Was there anything else you wanted to add? And then I'll just see if the other panel have questions for you.
Yeah, I would just like to, the only area of outstanding sort of drafting concern for me, and this may be just something that was potentially missed by the 42A officer in the restructuring of NATC R1 and sort of merging it with Eco R1. It looks like potentially my evidence didn't quite make it in front of Miss White for her summary response before the hearing, but Port Blakely's submission applied to all of NATC R1. They were primarily concerned with the areas outside of the high naturalness water bodies, but it did also apply to areas within those margins of high naturalness water bodies. And the Section 42A officer has recommended that that advice note solution could apply to all relevant parts of Eco R1, and also apply to all parts of NATC R3, which applies to earthworks. And I noted that it has been applied in NATC R3 for earthworks within the margins of high naturalness water bodies. So I wasn't clear whether it was an omission that it also wasn't applied to vegetation within high naturalness water bodies, or whether there was a deliberate reason why that had been missed out. And if it was an omission, I think there's scope to remedy that. If it was a deliberate choice, then all of the evidence that I've put forward about the deficiencies in the Section 32 justification for why there needs to be a departure from the NESCF regulations, all of that kind of comes back into play for that particular provision. So I think I'll leave that there, but that's the key area of outstanding concern from my perspective.
While you're here, I think that's something worth clarifying with Ms White. So if we can get a response now or an indication if more work's needed. Thanks.
Yes, so Ms Pearson, it's Liz White here, the reporting officer. I verbally confirmed to the panel yesterday that I didn't think that I'd done it intentionally, and at that point I hadn't given it a great deal of thought except that, but I have looked through it and I agree with you that because there was no intention, but also it would result in an inconsistent approach, and for all the reasons in terms of it wasn't something that was justified in the Section 32, and I think the same analysis applies to that equally. So in essence I agree with updating it to align with your evidence.
Thank you.
Thank you, Ms Pearson. I'll probably put this question to Mr Robinson around the utility of the bat monitor, bat monitoring tool. But in terms from a drafting perspective, are you in agreement with what was put forward in legal submissions at paragraph 29, the suggested amendment.
I was going to say I might need to find shown as legal submissions.
Excuse me, can I just add, Ms. Pearson doesn't have a copy of my summary of legal submissions. I only have hard copies with me on the day, so I don't think she'll be able to meaningfully respond to that question at this time.
Okay.
I am happy to provide something in writing afterwards, once I've heard the discussions potentially with, and the questions that you're going to put to Mr. Robinson, but very happy to assist on the drafting side of things.
Yeah, thank you. I think that would be helpful. And yeah, once you've listened, you'll be in a better place to be able to do that. Thank you.
And I think we've covered all matters, save for that particular issue. We might bring you back on to respond to that if you're in a position to do so today. Otherwise, we can accept something in writing. But thank you.
Sure.
So now we move on to our final witness, Mr. Zachary Robinson, who will either read from his summary statement or go straight to questions.
Just give us a quick summary.
Quick summary? No worries. Thank you for your time this afternoon, by the looks of it. Yeah, my name is Zach Robinson, currently Managing Director of Resolve Environmental, but previously worked for Port Blakely as their Health, Safety, Environmental Manager. In that time, and it's continued, we're heavily involved in the Longtail Bat Protection Program in South Canterbury, working with a range of stakeholders, including the Timaru District Council, on a whole wide scope of sort of projects, including monitoring, pre-harvest monitoring, habitat protection, pest control, very wide breadth of work there. I suppose in short, my submission is really based around alignment with the DOC protocols. The biggest concern I had with the proposed rules was the requirement for a suitably qualified ecologist, also then alignment with a suitably qualified expert as per the DOC protocols. The reason for that concern is not the output of the work, but more so the unintended consequences for farmers and small woodlot owners that just may not want to take on those costs, and will lose that social support and community engagement, and we won't get trees notified. Following that, the S42A report, we support that, or I support that as well, and we've had a chance, as Shona mentioned, to look at Simon Moore's additional submission, and also support that any use of the ABM monitors as point 7 of my summary needs to be applied as recommended in the DOC protocols. So the data from those ABM monitors needs to be assessed by a suitably qualified expert. I suppose that's a very short summary. I can carry on, but I'm more than happy to go straight to questions if you guys would like that.
Thank you, Mr. Robinson. My question relates to the drafting response that has been put forward in the legal submissions. So in the legal submissions, it was suggested that you're supportive of the evidence that was presented by Mr. Waugh. And so my understanding of our discussion with Mr. Waugh was that that the bat monitor was a useful tool and may or may not be used in the process. However, that it wasn't required to be a prescribed tool within this rule. Okay. While you're supportive of that evidence, you've also suggested to include the continued use of that. You're wanting to retain the use of the automatic bat monitor within the rule. So I'm not quite clear how to reconcile that.
I think as long as the rule is more focused on alignment with the DOC protocols and it allows for the tool to be used, as optional, not within the rule, because the DOC protocols themselves they've got sort of steps within that around whether ABMs become practical or not, and that will be guided by the expert that's undertaking that assessment.
Yes, that aligns with my understanding of
Yeah.
of Mr. Ward's opinion. So in that sense, the drafting put forward here was and supported through the use of an automatic bat monitor.
Happy for that to be.
Right. Okay. Thank you. That makes sense to me. And we did hear from DOC also, where they put forward agreed wording between DOC, TDC around the permitted 3 condition. It may not be specifically related to your submission point, but while we have you,
Yeah.
I was interested in, have you had a chance to look through that recommended text? Because it does deal with the protocols.
Okay. No, I haven't just yet, but I'm more than happy to have a look and provide some feedback.
Okay. Thank you. So
based
it
on
was
your question.
it's from memory, it was the permitted 3 condition attached to that rule that was new wording, and it was agreed and it was put forward by the River Advisor, and I've forgotten her name.
No worries.
Sorry, was that in the, contained within the submission of ECAN?
It was ECAN and, was it ECAN? Yes. Miss Jack and Miss Irvine.
Mm-hmm.
Yes.
Okay.
And it was decided and agreed, well, the words were, there had been some discussion between DOC
Okay.
as well. So it might, you might be interested in that. I'd be interested in your
Yeah, no worries. We can provide some feedback on that.
yeah.
And was that discussed in the Section 42A report as well? That
It was discussed in the Section 42A report, and then again in the summary statement. I think Ms White mentioned that there may be a further update by the submitters, and we heard that update yesterday.
Okay, thank you.
Thank you.
My question relates to the matters of discretion in the rule. So in Eco R4, and it was just about me understanding what your submission was on those matters of discretion. And so what I had understood your submission to be was when it came to identifying bat roost trees, that you were thinking that the competent person, as stated in the DOC protocols, would be sufficient and remove the need for an ecologist, but when it came to saying whether or not it should be removed, that would require an ecologist. Have I got that right?
Yeah, that pretty much aligns with the DOC protocols. It's sort of a risk-based approach. So the initial assessment of potential roost tree, there's a competency table within the DOC protocols, which is not an ecologist. It's just deemed their internal competencies. And then following that, if you have found potential roost trees or bat habitat using the ABMs to confirm that, that's when the ecologist is then brought in on how you would manage that and building a management plan around that.
Right.
Yeah, that's sort of the intention there, but it all aligns to the DOC protocols essentially.
That makes sense, yeah.
yeah.
So what I was struggling with was going, why wouldn't you just have one person do both? But actually,
Yeah.
in fact, practically, to just
yeah.
come and identify the tree, you might not need an ecologist.
Yeah, essentially, if you're looking at those criteria of a tree, you don't really need an ecologist to do that. And then with the ABM monitors that we do have available if required, we can pick up in the right time of year bat activity. Assessing that data can be done by the internal DOC staff. Very rarely do we have any ecologists operating in the South Canterbury Pika Pika program currently. We have some very experienced experts, the likes of Simon Moore, but currently, as the proposed rules stand, that would really negate the effect of the monitoring that he does. And obviously the cost of bringing in an ecologist for everything would, I think it would have some detrimental effects. So it's a bit of a hierarchy sort of management tool.
It makes sense now, thank you.
Yeah.
Thank you. Firstly, I just want to acknowledge the great work that Port Blakely does in our community for the long-tail bat. Yesterday I acknowledged that I did not know much about them until 2 weeks ago, so I just want to acknowledge your company for the work that you do in our district, so thank you.
Thank you.
I just have a couple of questions, and one is around we've heard a lot about engagement with landowners over the last couple of days, and when I reviewed, I think, Mr. Robinson, your report around the stakeholder group, and obviously Port Blakely is the only landowner within that stakeholder group, I just wondered, is there a gap in there that there are no other landowners, or is there any other landowners that are as large as you that are not there? Or how does that group actually continue this engagement? I couldn't see anywhere in there. I just wondered if you could help educate me a little bit.
Yeah, it's a great question. It's something we identified probably about 12 months ago as a group, that the whole program is really at risk from organisational commitment. So based on that, we produced a South Canterbury Pika Pika strategy and implementation plan, and we're looking at the governance levels of that and how do we gain some sort of a charter and get people on board. The other side of that is, without the funding of the likes of Port Blakely, currently, as you know, the Department of Conservation funding changes rapidly. This program is at risk. So, that sort of also triggers the adding more red tape around it. We really might lose the support of the community. I think the other, within the stakeholder groups, I think most of the other colonies are on public land. Port Blakely are fortunate enough to have two within their forests, one in Māori Gully and one in Raincliffe. We're always looking for more engagement with communities and stakeholders. We've had really good uptake when we've held bat community nights, running buses out and looking for bats and running around the bush, which is good fun. We haven't lost any kids yet, touch wood. That we know of, yeah. But yeah, it's a really fantastic program for the community in South Canterbury. I think it's got huge potential, but it most definitely needs that community support and engagement. And as we know, restricting with rules can really hinder that. So making it, nice and practical, I think is going to be really important.
Another little bugbear over the last couple of days has been around the bat protection overlay and the Canterbury maps. And obviously, I think Doc presented some great monitoring points, and you could see that the Canterbury map overlay would support their monitoring program. But what are your views? Is that a step too far? Some of our submitters are talking about SNA rather than extension of the overlay map. So you haven't talked about it much in your submissions, but I wondered, does it impact your current operations, or are you obviously within it?
Yeah, it's a difficult one, I suppose. We know where our habitats are through the monitoring work we do, to the point we've actually identified our maternal roost trees, which are essentially where very vulnerable during the breeding period. All the females will go into that one roost tree. So when we've identified them, we've actually protected them, so they're all GPS mapped through our forest. They've got predator bands and signs on them. As far as mapping, they're a highly mobile species, and it's probably one of the most difficult things I think all district councils are dealing with around highly mobile fauna. It's how do you put a sort of, it's very, very hard to manage, because it's not like it's in one area, it's not like it's in a SNA where it's not going to move. So I think more of a practical approach around landscape scale predator control and monitoring. And then when identifying those colonies, there's the Conservation Act, there's the Wildlife Act, there's those sorts of tools as well. I'm not sure. Yeah, I think the mapping overlay, I don't really have a comment on it, I suppose. Yeah.
Well, I'm going to change the topic completely, and I want to get into the monitoring part of it. I've read your monitoring results, and I've just got a couple of questions around that. I'm reading, have you got your monitoring data relating to a harvesting operation in Raincliffe Forest in front of you?
Yep, sure do. Thanks to Shona.
I just want to know why the activity was down during the pre-harvest monitoring.
Great question. So there was a very complex harvesting, as Barry would know. He looked after this, and it was probably about 2 years of planning? About 2 years of planning, because it's probably the first time we've actually done or completed harvesting within a known bat habitat. Department of Conservation experts are involved with this sort of whole period. And essentially, the reason for the harvesting was storm damage. There was a whole lot of western red cedars that had blown, had 2-3 storms through it, and the forest was locked up, and we had to clear it. Long-tailed bat or peka, they like feeding corridors. They like the sort of open, sort of like creek hedges and things like that. This forest was very closed in. If you know what the western red cedar stand, it's very, very dense. We went through and marked and left every potential roost tree. So we didn't do the assessment as such. We just followed the guidance, and where the broken tops or anything that could be a cavity for peka, we left. So you wouldn't want to take a forester there, because it looks completely opposite of what a forest should look like after harvesting. But following that, like the activity pre-harvest monitoring, there was very little room for them to feed or forage through there. Following that, I should have probably had some photos in there. It's sort of quite an open stand with potential roost trees through that. We'll carry on monitoring in there and see if they are using any of those trees as roosts, but it was very clear from the post-harvest that they're operating through, they're using that area for foraging. It was a real success story, in my opinion, I think, of how you can manage productive land use and work with Indigenous species. So credit to Barry and the team.
And that's probably why it was so busy in the post-harvest, because they had room to fly.
Yeah. And we didn't just use the ABM monitoring for that. There was thermal cameras set up for pre-harvest. There was trees that were marginally, potential roost trees. They were checked before they were removed. It was a very complex operation. But yeah, it's great to see that activity's really increased through that area. There's 26 known maternal roost trees in the Raincliffe Forest. None were in this area, but there's already a colony there, so we've just created more habitat for them to feed and forage, I think.
Does it take a lot of skill to recognise roost trees?
I think the potential roost trees could be anywhere. If you look at the 256 roosts that have been identified through South Canterbury, the specifications of them is quite varied. So I think it's more around, it's a practical approach, and the engagement with the Department of Conservation. We've got a very good working relationship with them. We've got invested in around 20 automatic bat monitors for the community. We can put them out, we can analyse the data, and then review it with Department of Conservation and work from there. But I think the criteria that are in those rules they're going to work.
So when does, I'm trying to work out, when does harvesting take place? Like, obviously you'd avoid the torpor when they're in torpor, wouldn't you?
Yep.
Yeah, so would the harvesting take place outside of the winter months?
Yeah, so you might be able to answer that, Barry, but essentially we do our monitoring, anything that would beat a potential roost tree, we would hold off. Barry would have to have some conversations with everyone else about holding that job off until the warmer months when peka are out of torpor. Yeah. We'll do our monitoring based on that. We'll analyse the data. There's been very few times, apart from this job, where there was a potential roost trees. There'd be activity, but that's where the experienced experts come in with. You're not just looking at bat activity, yes or non-detected. You're looking at time frames, so when they're leaving, in the dawn or dusk, and the activity and then how strong those readings are would indicate how close they are to a monitor. So there's a lot goes into that side of it, which is why, totally support Simon Moore's requirement for those ABMs to be used by a suitably qualified expert.
Oh no, well thank you. I think Port Blakely does a wonderful job as well, looking after the South Canterbury bats. We wish we had more bats up north, further north.
There's a few rays going to take them home. Put them in a window.
But thank you. I have no further questions.
Thank you very much.
And I have no additional questions. Thank you very much for your evidence. It's been most informative. Just before we finish off. Ms Pearson, did you want to offer a comment now in terms of that amendment to the rule, or are you happy to just, we can add it to the list of post-hearing responses and you can
I
respond?
think I'd be able to give you a better response in writing once I've had a chance to look at all the different versions of the suggested wordings together as a package, but very happy for that to go to the list.
That's absolutely fine. Thank you. So I think that's all, Ms Walter, unless you've got anything else you wanted to add in closing, but I think we've got a good understanding of Port Blakely's submission and the potential remedies that have been progressed through discussion with Council.
Thank you, Madam Chair. Commissioners, that concludes the case for Port Blakely today.
Thank you.
Thank you.
Right, we'll take our lunch break now and we'll resume probably at 1:20 p.m. to hear from BP Oil, Mobil Oil and Z Energy. Thank you.
Madam Chair. Wondering, we've got only those two submitters left and they both relate to Mr Willis's report. So I'm just wondering whether Ms White and Mr Boys could be excused for the afternoon.
Absolutely, that's fine. Thank you. We are hearing now from the oil companies. We have Ms. Westerby and Mr. Travella on video link. Welcome. Can you hear us okay? We can't hear them.
Can you see and hear us clearly?
Yeah. Can you
Thank
speak
you.
up or increase the volume a little?
Yep. Can you see and hear us clearly?
Yes,
Yeah?
thank you. That's all
Okay.
good. Welcome, and
Thanks.
look forward to hearing your submission.
Thank you very much. We'll start off with introductions. Good afternoon to the panel and the council's officers. My name is Thomas Chevalier from SLI Consulting, a senior planner, and with me is Sarah Westerby.
Kia ora koutou.
So we're presenting our joint planning evidence for the field companies, which comprises BP, Mobil, and Sun Energy. Our evidence focuses on their submissions on the contaminated land and hazardous substances provisions. We note that we've had pre-hearing correspondence with the Section 42A officer, Mr. Willis, to clarify the field company's submissions, as well as Prime Port's consultant planner, Kim Seaton, regarding areas of alignment, given the submitter's shared interest in hazardous substances and major hazard facility provisions. We've also read Mr. Willis's opening statement and acknowledged his updated recommendations on various hazardous substances provisions. Madam Chair, with our evidence taken as read, we'll go through a brief oral summary. We've split the speaking roles, so I'll go through the contaminated land points, and Ms. Westerby will go through the hazardous substances points. However, we share the same opinions and can respond to both questions for both topics. Our plan is to pause at the end of the contaminated land topic, followed by questions, and then move on to hazardous substances.
Thank you.
Thank you. So for contaminated land, our evidence focuses on two provisions. As both are still in contention, I'll just go through the key points. The first provision is Objective 1, which we analyse on page 7 of our evidence. We disagree with the Section 42A report's amendment so that it requires the disturbance, development, or subdivision of contaminated land to not result in any risk to human health. This is a significant change in policy direction, and we consider this to be contrary to how risk is managed under the RMA, i.e. the RMA doesn't seek the avoidance of any risk, and the intent of the NES, i.e. the NES seeks that contaminants and adverse effects on human health are managed. Furthermore, none of the chapter's policies seek that activities avoid or not result in any risk. In our view, Objective 1's intent is already appropriate as it seeks that contaminated land is made safe for human health and, importantly, its intended use. The term intended use arises from Regulation 7 of the NES, and it recognizes that the level of risk and control should correspond to the sensitivity of each use. Intended use is also referred to in Policy 2. Therefore, we recommend that Objective 1 is retained as notified, subject to the replacement of land disturbance with soil disturbance. The other provision is Policy 3, which we analyze on page 9 of our evidence. After further consideration, we've identified 3 issues with this policy. The first issue is its purpose. As Clause 1 of Policy 2 already seeks that contaminated soil is managed to protect human health, we question whether Policy 3's purpose is clear and if it's even necessary. The second issue is its drafting. The policy reads more as an objective as it doesn't direct how the activities should be undertaken to ensure that human health risks don't increase or are potentially reduced. Good policies are prescriptive. For example, we note that the chapeau of Policy 2 at least requires activities to follow a best practice approach. And the final issue is the meaning of management works. While remediation is well understood, it's unclear to us as to what activities management works relate to. It isn't defined or used elsewhere in the PDP, nor was this policy explained in the Section 32 report. Overall, we raise these questions for the Council's officers as to Policy 3's purpose and drafting. we consider that the policy should be re-evaluated and, if it's still considered necessary, further clarified for plan users. Thank you. We're open to questions for this topic.
Okay. Thank you. Just to clarify, so the relief that you're seeking in relation to CLP3, is it just deletion of the policy altogether? And does there need to be any consequential changes to P2, or do you think P2 sits fine as it is without P3?
At this point, I think we were just posing these questions as it's unclear as to the intent of the policy because it's already covered by clause 1.
Yeah, if I may, I think it could be helpful if we understand what management works means in the context of that policy. And if that's clear and it seems reasonable, would be okay with it. But I still think it lacks a bit of direction, what a policy should do. So I think it could go, because I'm comfortable that policy 2 is quite clear and covers what it needs to in the context of the NES for contaminated soils and all of the guideline documents that are embedded in that.
Just to short circuit things, Mr. Willis, I'll put you on the spot, but just in terms of what the issues now are sort of being clarified as being, are you in a position to respond to that now, or do you want to reflect on that and leave that for an interim response?
I might do both, actually, Madam Chair. Noting that I didn't draft these provisions, I do think there is some overlap between CLP2 and CLP3. I think CLP3 is intending to focus more on the actual works when they're undertaken, when they're done, and the management of those, as opposed to, I guess, the outcome of post the works, that the site is actually safe for human health. And I think that's the intent between that split. Although I do agree that there's some overlap between them, because you can argue that in achieving P2, proposal to subdivide, use or contaminate land, then you have to manage contaminated soil, and you could argue that includes the process of remediation. So I think there is overlap, but I think they're potentially slightly seeking different things, but I think they can be merged or made clearer, and I think that's what management works is, basically, whether you're digging the soil out, shifting it off-site, or capping it, or doing whatever it is that you are doing to it, that's what management works is. It's the process of making it safe. That's my view.
Okay. Can we just perhaps suggest that, staying within the scope of the submission that's been made, that if you work offline perhaps with the oil company cleaning team, that might provide a more constructive way of resolving the issue. Are you comfortable with that?
I'm comfortable with that, Madam Chair.
Ms. Westby, Mr. Treville?
Yes, absolutely. That sounds like a good plan.
Thank you. I do have a question around the objectives statement. So, Mr. Trevilla, you have talked us through in your evidence and also today that you're feeling uncomfortable about the recommended change to that provision. I'm having trouble understanding the problem that the current drafting creates. Could you just talk us through that again?
In terms of the recommended amendments?
Yes.
To Objective 1?
Yes.
Yeah, and I think, just to clarify, I think the problem we highlighted was the introduction of the phrase that any activities, in essence, does not result in a risk to human health. So it's the a risk, which I think is our problem.
Yeah.
Do you want to run through why?
I guess, yeah, our view is that the existence, of risk doesn't necessarily mean that there's an adverse effect.
Yep.
And, for there to be an effect, there must, be a pathway for contamination to the receptors, which is humans. And
Maybe just by way of example, if we're going through, I don't know, an activity for some earthworks, contaminated soil, that needs a consent and we're running through that objective, inherently, because you're working on contaminated land, there is a risk. There's always going to be a risk of that activity. And so it's about how you manage that risk, and it could be managed poorly or it could be managed really well. But there's always going to be a risk. And I think that was the point we were trying to get to, and that the RMA isn't directing to avoid all risk or avoid all effects either. So
Thank you. That's helped me understand the problem that you're seeing. I guess following on from that, my question is that the objective is an outcome statement which is supported by a suite of policies. So if you were to read the objective in isolation from any other policy support, that I can see where your concern lies, but the policies, if there was a risk identified, the policies are in place to determine the extent of that risk. You'd then go through a process, would you not?
yeah, that's fair. I'd agree with that. Yeah.
Okay, thank you.
Move on to the next topic.
Okay. Okay, so the hazardous substances chapter. Moving on. So I'm only going to speak to the matters that I see are outstanding, and I think some are resolved, so I won't go there, but happy to answer questions on anything. In relation to HSP1, Policy 1, which is new major hazard facilities and additions to existing. So their policy initially read as dual purpose, in my view. The first purpose being to avoid unacceptable risks, which is defined and specifically relates to the risk of human fatality from MHFs, and that's embedded in the definition. The second purpose is to manage effects from natural hazards on major hazard facilities and vice versa. Initially, hazard facilities, which were the non-major, so everything else, they've been removed from this policy now as recommended by Mr. Willis in his 42A report, and we support that, so that's helpful. So avoiding unacceptable risks from major hazard facilities is, in our view, quite a different assessment process to follow than that of Clause 4 of P1, which seeks that suitable measures are undertaken to manage adverse effects on or from natural hazards. Quite distinct and different in my view. And so we have listened to the opening statement yesterday of Mr. Willis, and we've read his summary statement. In that, Mr. Willis states that he considers now that it is appropriate to have these resource management matters separate policies, and so we support that principle. Right, the next policy I'll speak to is P4, briefly, which is hazard facilities other than MHF. But the appropriateness of this policy, in my view, comes down to the definition of the new term sensitive locations and any corresponding rules pertaining to sensitive locations. So I won't speak to that policy, I'll move to that definition. So sensitive locations, I know you spoke about it yesterday, and it came through the 42A report. As I understand, this definition is limited to the hazardous substances chapter, which is helpful. It includes a number of natural hazards and sensitive locations, but it now excludes many other types of sensitive activities or land uses, such as heritage. That's broadly supported. I also understand that Mr. Willis has considered the wetland, his words, double counting matter that we raised in our primary evidence, and so I understand he considers that favourably, but we haven't landed on what it needs to look like or say. We discussed this at 8.19 of our primary evidence. I'm happy to speak to that if there's any questions on that. So moving to rules. Rule 1, the use or storage of hazardous substances in hazardous facilities, not major. So overall, we consider that the new definition of sensitive locations is better suited in terms of this rule and how it's framed. There are many types of use and storage of hazardous substances that we are not familiar with, but what we are familiar with, and specifically, is underground storage of fuel at service stations and truck stops. This land use activity is heavily controlled by other legislation. Underground tanks are not particularly sensitive to earthquakes, certainly not modern tanks, which are double-skinned fiberglass in an engineered tank pit. Underground tanks often sit in groundwater. They're not susceptible to flooding or any other type of water. The Canterbury Land and Water Regional Plan has a passive discharge permitted activity rule which must be complied with for both existing and new activities. So actually it controls more than what a district plan for future activities would. And it has the permitted activity rule for the passive discharges no matter what the activity is, irrespective of if it's defined as a major or a hazard facility, any activity. So compliance with this rule should manage effects on drinking water resource, irrespective of the sensitivity of that receiving environment. So we've been unable to ascertain what additional district resource management issue is not addressed by other plans or other legislation. And by that I mean the inclusion of sensitive groundwater or sensitive drinking water areas in the sensitive locations definition. On this basis, we recommend it's appropriate to exclude underground storage at service stations, which includes truck stops, from this rule in all but a few of those sensitive locations. Locations that it may be appropriate to avoid underground tanks at or within, unless you get a resource consent. Coastal inundation, and potentially within 250 metres of a major hazard facility. So it's those two that I think can probably stay. And just a clarification, actually, which was in our evidence, we included liquefaction awareness area in the relief sought to Rule 1 by way of an exclusion addition. And that was an error because that is not included in sensitive locations per the Section 42A. And just finally, I'll just speak to 4, but I don't even think I need to, based on what I heard yesterday. But the only previously outstanding matter in relation to Rule 4 was that owing to the changes to R2 that were agreed, additions to major hazard facilities can be removed from the title, essentially, of that rule and the intent of that rule. And we understand from yesterday that Mr. Willis agrees to this. That's all I have to say. Thank you.
Thank you for that. Could you just clarify with me your statement just now that underground storage tanks are not susceptible to a number of natural hazard risks? I just wondered what the evidential basis was for that point.
Yep. It's probably best to go through each of those hazards that have been sought to be controlled or sensitive areas. So I'll just go to that definition. So we've got earthquake fault awareness overlay. One moment. At 8.27 of our primary, we provide some evidence on this matter.
Just let me find that.
Yeah, no worries. Actually, 8.28.
8.28, 8.27.
Yeah. Well, it could be 8.27.
8.28.
Yeah, 8.28. Page 17. The evidence was from the Christchurch earthquakes, which I understand were quite bad, but to be fair, there could be worse earthquakes. But those tanks are old, so they were mostly steel tanks, single contained. New activities, which will be subject to the new regulations. Some of those tanks were installed about 30 years ago in Christchurch.
I'm not sure that you're clear. Are you going to call, in the context of the natural hazards hearing, expert evidence in relation to the susceptibility of underground storage tanks to natural hazards? Not a planning evaluation.
No.
But it's
No,
presumably, are you relying on a engineering report or technical analysis of the impacts of earthquakes on underground storage?
Yep, so it's based on the evidence from our clients from those events. And
that's not in front of us at the moment?
No, that's just through my understanding from the clients.
Yeah. I think we probably, in the context of the natural hazards hearing, if you're intending to appear then, it would be helpful if you could call expert evidence, or your client could call expert evidence to support conclusions, to support the policy response or the regulatory response in the context of the district plan.
Yep. I mean, we can certainly think about that. I don't know what submissions are primarily on those chapters, and I understand it gets a little bit difficult where you've got trying to manage similar things in two different chapters.
I think that's been flagged by Mr. Willis, that there are some, and then there are other areas as well in the context of this hearing where there might be, I mean, we're not making decisions on this chapter in isolation of considering the bigger picture, but you will appreciate that generally we would expect a planning witness to be relying on expert technical evidence in some form in the context of the hearing before we could make a change that you're suggesting to the policy framework.
Okay.
Thank you. Commissioners, do you have questions on this particular issue?
Mine was actually, it was very similar to that question that's just been asked, but it was when I actually brought up the maps and I put the overlays on, I couldn't see that a large area was going to actually be impacted, so I was more interested to know if those layers applied, what the practical consequence would be for your client, because they seem to be quite small areas, but it might very well be that we have that evidence in a later hearing.
I think that's a fair point. There's a lot of these areas that are really isolated in terms of where they are mapped geographically, albeit that could change. So the chance of new underground storage is pretty low, first and foremost. So this isn't something that's going to be coming up time and time again, and it may not ever occur, but in my view it's still important to get these provisions right if something did occur. It may be that those types of areas are avoided anyway, irrespective of the plan. There may be, and I'm not a scholar in each of the other pieces of legislation, but there may be things in the building code, the Health and Safety at Work Act, and hazardous substances and new organisms regulations, of which there's a lot, that would control those sorts of things. And so just sort of turning back to that second question, the first question, in fact, the way I've, for the last few years, understood the intent of the 2017 RM changes was that if you are to control hazardous substances in a plan, you need to demonstrate that you need to, as opposed to it being the flip side, which I think you've sort of asked me to do. A little bit conflated with the natural hazard issue. Oh dear. And I understand that. But if this is a hazardous substances chapter, which should manage hazard substance land use, my view is that you need to demonstrate that you do need to control it beyond what anything else controls already to avoid duplication, etc. So, yeah, I accept that there's a natural hazard aspect to this too, which is slightly different. Yeah.
Thank you for that. Just in terms of, I mean, we're having to evaluate what the most appropriate method is to respond to the issues, and you've flagged the risk of duplication or the potential for duplication with other pieces of legislation. Can you just, in a nutshell, just what is the relief that you're seeking in relation to that, to these particular provisions?
Generally or specifically? Because we've outlined specifically what our relief is.
Are you seeking to simply default to the other regulatory frameworks outside of the district plan, or are you asking us to build into the rules appropriate recognition for those other processes as part of the assessment as to the necessity of the particular standards?
I think neither. I think that any rule that is proposed or provision that is sought is absolutely fine if it's been determined that there is a gap in regulation and a gap in control. And happy to hear from the council if some of these rules and provisions have been proposed on the basis of such an exercise, but I just haven't seen that.
And have you done that exercise yourselves? Have you identified a gap at all?
No, we haven't.
All right, well, I think I'll leave it there. I don't think there's any other questions for you. Okay, thank you very much for your evidence.
Great, thank you.
Thank you.
Cheers.
Tēnā koutou katoa. Thank you for letting us present our case today. So I'm here for Primeport and TDHL. Submissions and further submissions have been lodged on the district plan. Today we're here to talk about wanting to ensure that the activities of the port, but in particular the supporting and related activities occurring within the port zone, including relation to hazardous substances facilities, are appropriately recognised and provided for. With me today, you'll hear from Tony Cooper, who is the Project Manager and Engineer of Primeport. He will be outlining for you the strategic and regional significance of major hazardous facilities in the port zone. You'll also hear from Kim Seddon, who's a planner, who will be detailing the provisions for you and also the amendments that we'll be seeking. Also with us today is Fraser Monroe. You will have heard from him back in hearing A. He's here again today just to answer any questions you might have for him arising from what he said before. The reason he's here is he has talked about petroleum products being in the port zone, their importance for being there, how they enable low-cost supply of petroleum products into the region, and also about how if the port was unable to have these facilities operating in the port, then we have a situation where the region would need alternative supply chains, extended transport cost, shipping, or land shipping, if you like, fuel into the region, higher cost of petroleum products. But again, if you've got any questions about that, please feel free to ask Tony and Fraser here today. So my intent is not to read through my legal submissions, but just to give you an overall outline. I am not repeating the legal framework which I provided to you back in the first hearing, and also did outline the higher order documents for you. They remain relevant here. The one thing I do want to emphasise, though, is that the higher order documents do seek to make sure that the lower order documents like this district plan will provide for a range of activities associated with the port that have an operational requirement to locate there. And what we are saying is that major hazardous facilities and hazardous facilities generally do have an operational requirement to be there. I don't want to say too much about the contaminated land provisions other than to point out that we did lodge a submission supporting that chapter. It has objectives and policies, which is appropriate because the rules are dealt with in the environmental standard. We did lodge a submission opposing Forest and Bird wanting to insert rules in there, but as I understand it, they haven't provided any evidence about that, so we don't need to say too much about that other than the chapter's fine as it is.
On that, Mr. Cairns, just from the previous submitter and just the changes they were seeking to the policies and perhaps the duplication or not in relation to P2 and 3, if Mr. Willis is going to work with the oil company planners, it might be worth Ms. Seaton perhaps being involved in that discussion as well.
Yes.
Thank you.
And we'd be happy to participate just to make sure that, you know, objectives and policies are still fit for purpose to work with the environmental standard. Thank you, ma'am. So really we're here to predominantly talk about the hazardous substances provisions. Now, just stepping back, there's quite a high degree of alignment between us and the reporting officer and the oil companies, which is as a consequence of some good discussions that have been happening in the background. And so we do agree with that from the whole chapter perspective, it does appropriately focus on major hazard facilities. We don't need to deal with the nitty-gritty of how HAZNO works or the Health and Safety Work Act, no need to duplicate any of that, so that's all good. So briefly, just want to record that we agree with Mr. Willis's recommendation to amend the Objective 2, which deals with reverse sensitivity on sensitive activities. It is appropriate to capture reverse sensitivity, not just from new sensitive activities, but expanded versions of that. So we're all on board with that. However, I think I want to concentrate a little bit on policy HSP1. There are two clauses there. It's clause 3 and clause 4 that I'd like to just elaborate on. The reason that Prime Port and TDHL opposed clause 3 of that policy was because there was a disconnect between how that policy would work and the rules. So the clients I represent are accepting that new major hazardous facilities in the port zone should go through a consenting regime. So we agree that new major hazardous facilities need resource consent. Additions or expansions greater than 10% do need resource consent. But the problem was that policy P1 clause 3 as written would have caused any resource consent process to try to jump through an avoidance policy, avoid these things in the port zone. So there's big inconsistency here. Now, as I understand it, there is conceptual agreement between Mr. Willis and my clients, and that there is a need to address that policy. We shouldn't be seeking to provide a consenting path and yet hamstring it by having and avoid these facilities in the port zone. So where the disagreement is, or maybe it's not a disagreement, it's just we haven't landed on this, is how best to draft the policy to provide for that. Now, Mr. Willis has proposed a definition inserted into that policy to essentially, avoid these major hazard facilities outside what's called sensitive locations, but unfortunately the way the sensitive locations definition is written will still capture the port zone. So again, it's just hamstringing what is clearly a consenting path. And so I've set out in legal submissions at the top of page 7 our suggested way of just making sure that the port zone isn't inadvertently captured by the avoidance policy. There may be other ways to do it, but certainly that's one that we say will work. With regards to clause 4 of that policy, Prime Port and TDHL actually lodged 2 submissions, a submission and a further submission. We did lodge a submission supporting that notifies clause 4 because we thought it was appropriate that if you were to have major hazardous facilities in the port zone, then there should be measures taken to minimise adverse effect. I mean, that's a practical requirement. So do you like the gist of that policy? But we also lodged a further submission supporting the oil companies, which was to pull the gist, if you like, of that clause 4 from that policy and make it a separate policy, just to make it clean. And in hindsight, we think that's the better way to deal with it. And so in 614, at the bottom of page 7 of my legal submission, I set out there our version, if you like, of how we can just set it apart from the confusion being linked with that, the rest of the clauses in policy 1. So we think a standalone policy just works better. Having said that, we have looked at the oil company's version of that policy. It is a slight rewording. We don't have a problem with that either. But I think conceptually it's just neater to have it as a separate policy. Now, I want to deal with policy P4, which deals with hazardous facilities other than major hazardous facilities. Just briefly, Mr. Willis has agreed, again conceptually, that there is a problem with the notified version of that policy. And again, he does agree conceptually that the port zone needs to be excluded from that policy because, there is an operation and functional need to have hazardous facilities there. Where I think we come a little bit unstuck again is how we provide for that outcome. Mr. Willis has suggested using the sensitive location definition again. I'll come back to that point because it doesn't quite exclude the port. And so, yes, it comes down to how can we make sure that the sensitive location definition clearly exclude the ports. Rule HSR1 has the same problem. There is, again, recognition and agreement for a rule that deals with the use and storage of hazardous substances, but again, we need to deal with the port. Mr. Willis has again suggested using the sensitive location in there, but again, it inadvertently still captures the port. I won't deal with R2 or R4. There's agreement there about the fixes needed. It's just minor fixes, but I do want to really concentrate on the definition of sensitive location, which is on page 10 of my legal submissions. The way I describe Mr. Willis's proposed definition of sensitive location is the partial exclusion, but not a full exclusion of the port zone. And the way the port zone still comes in is the definition of sensitive location still captures high hazard areas, which includes seawater inundation areas, which captures at least part of the port zone. And I recognise that what is a high hazard area will still be a matter for you guys to consider next year when we deal with the natural hazards hearing. But I think the agreed outcome is simply this. However we cut it, however we draft the sensitive location definition, we simply just need to exclude the port so that the hazardous substances provisions will work. And our suggested fix is set out in paragraph 7.3 of my legal submissions, which is basically put up the top, excluding the port zone, then you can define sensitive location however you want. And then we get the outcome that we're all conceptually agreed with. And finally, just want to say that regard to the definition of hazardous facility and the planning maps in Schedule 2, we agree with a little minor tinkering there just to clean up the plan, and we're happy with what Mr. Willis has suggested there. If you have any questions, I'm very happy to answer them.
Questions, Mr. Karansayer? That's all clear. Thank you.
Thank you. In that case, I'll ask Tony to provide you with an outline of his evidence next.
Thank you, Madam Chair. My name is Tony Cooper. I'm the Project Manager, Civil Engineer Advisor at Prime Port. I've been in that role for about 4 years. Prior to that, I was the infrastructure at the port, infrastructure manager at the port for about 5 years as well. So I'm quite intimate with the area and worked on a number of projects in there and have a quite good understanding of what the port needs are. So what I'd like to cover with my presentation is what is the strategic importance of the port for both the South Island and for the Timaru area, Greater Timaru area. And in particular, the major hazard facilities. So currently there are 4 major hazard facilities that have been constructed within Prime Port. 3 facilities are used to store and process and distribute imported petroleum-based products. 2 of those are operated by Z Energy and 1 Timaru Oil Services. Now, Timaru Oil Services is a newcomer to the region, and they've only been here now about 4 or 5 years. And that new oil service coming to Timaru didn't happen over 10 years of planning. It was something that happened relatively quickly. It was all planned and built within a matter of about 2 years. So these opportunities for putting in new facilities for major hazard facility sites do not have a long planning period. They're short, and we as the port have to be agile and prepared to facilitate that. So not only do we need to help them get appropriate land to have their facility, but we also need to, in the case of the petroleum company, have a pipeline for them to take their fuel from the wharf through to their facility. So the way the system works in Timaru is that bulk petroleum and bulk liquid chemicals, which is what's coming to the current facilities, arrive at the port in MR tankers, and they're pumped via underground steel pipelines to their facilities. Now, typically, deliveries would be around 10 million litres at a time, which roughly equates to 250 fuel tankers. And the sort of storage tanks we're talking about are 5 to 8 million litres. Okay. All of the facilities in Timaru for major hazard facilities are fully bunded, and we had a tank put in recently to the Ixom site, fully bunded, 110% capacity, and last week we were looking at the cameras and seeing they'd filled it up with water to test how efficient that was. And if there was any leakage there, they were going to have to fix that. So a great deal of over-design went into that structure. Not only does that stop leaks, but it stops inundation water going into those sites. The petroleum major hazard facilities are lifeline utilities, vital for the supplies to the South Canterbury and North Otago regions. And without these facilities in the port, the reality is that there wouldn't be any shipments coming into the port of any volume, they would be coming via road tanker from Christchurch and from Dunedin. And that would add significant costs to the economy as a whole for this region. So strategically, very important that we have those facilities, not just for the existing products that are coming into Timaru, but we've got to be prepared to deal with future products, and that could be liquid gas, anything with the changing government policy, that could well be on the table. The volume of bulk liquid storage on site is driven by operational needs and supply risk. So the current storage volumes are basically driven by the operators on what they want in the current economic climate. However, in a disrupted global economy, the reliable supply of fuel is questionable, and that could well act as a driver to increase site storage, either by the choice of the operator or as driven by the government. And at the government level, the closure of Marsden Point and the deteriorating global stability has raised concerns over that security of petroleum supply and storage. There have been various discussions in the past 2 years with suppliers out of Timaru to discuss put in another fuel tank. They want to see more fuel storage. They want to see above 20-day average storage for fuel in New Zealand. That hasn't made any progress yet because of the stumbling block as to who's going to pay for this. And obviously the operators don't want to until they have to, and the government can't afford it at the moment. But the reality is that is potentially there. And going forward, we need to be in a position where there are no barriers in the way, and getting the consent's not a barrier at all, as long as it's a smooth consenting process to put big tanks on the site, and they won't be little tanks, they won't be 10% increased storage, so I really can't see the permitted activity clause of 10% actually being used at all to gain extra storage. It will be another tank, and even for the biggest site, that's over 20%. But as long as the consenting process is a clean consenting process, there's no barriers in that consenting process, then we can work our way through that for existing sites. And on new sites, again, we need to be able to fit into that small port zone area. And it's likely for major hazard facilities, they'll want to be closer to the port rather than at the southern end of the site. Talking about general hazardous facilities around the port, we have a number of those around the port, and we'll continue to need them in the future. These include smaller fuel tanks, such as bunker tanks used to support the shipping link to Chatham Islands. That's just one example. It could end up being ag chemical storage going forward. We're not talking of huge facilities, but we need to be able to operate those within the port. So, yes, that's all I've got to add. If there's any questions.
Thank you. Any questions? So my questions are more about the impact of the current sensitive locations definition and how that may impact. And so if we were talking, just take the 250 metre part of that definition to say it needs to be 250 metres apart. And I'm looking at your photograph and your evidence on page 5, and we also have done a site visit and gone and seen this all for ourselves. Yes, yep. So are these major hazard facilities currently separated by a distance of 250 metres in any event as just part of ordinary business, or are they closer than that?
They're closer than that, some of them, and that's historical. And the question I would ask is, if I had 4 fuel tanks on one site and 4 fuel tanks on another site right next to each other, owned by separate companies, it's an issue. If it's owned by one company, it's not an issue, is it? So, can you see where I'm coming from there. I'm talking about fuel storage, because there are 3 of those and only one other major hazard facility.
Yeah.
So
is there a risk, though, of having them too close together? If something happened to one, is there a higher risk if it's in proximity to the other?
well, the industry's governed by rules regards to proximity of tanks within a site and things like that. So if it's good enough to have a tank on one site, you go to Auckland, there's 10 or 15 tanks on some of those sites. And they would be in a similar proximity to what we've got. The fact that they are separate sites, personally, I can't see what the issue is. There may be an issue when it comes to different types of hazard facilities proximity. I can accept that. But what we've got is what's been there historically. And most of those sites go back a long way.
And they do seem to be kind of grouped together in a particular area of the port.
Yeah, they need to be close to the wharves because they've got pipelines connecting them to deliver their product. If we didn't have those, if they were, say, 2 kilometres away, then you've got the real issue of how do you pump oil 2 kilometres? And the answer is you can, but it's far more complicated and expensive than, I think the furthest we pump now is about 800 metres.
And when we were there, I think there was a new pipe being constructed at that time. I felt like there might have been, but...
When you're on site? Yes, the Exxon's, so we've rationalised old pipe work between the Exxon site, which is the chemical storage area, and the 1X Wharf. They've all been replaced and upgraded, so there was a whole load of pipe work going on there. Those are very short runs. They're only a matter of a couple of 100 metres, but the long-run pipelines run to the likes of Timaru Oil Services Limited, and that's well over a kilometre of pipeline because of the route it has to take to get to the site.
And when I look through the rest of that definition, there'll be some things that are just not relevant, like drinking water protection area, I don't think is quite relevant for yours, is it?
Well, it's no drinking water sources, no.
And so it seems to be that seawater inundation.
Seawater inundation and the flooding events are what we're saying, well, those sites are bunded. If product can't get out, water can't get in, I'm not quite sure what the hazard is. If you're talking half a metre or even a metre inundation. And the planning maps do show flood areas, which I personally don't believe are possible, but that's another matter.
No, that's really helpful, thank you.
My question is just around this 10% volume. And I note in your submission, Mr. Cooper, you sort of left it up to the oil companies to it's not your level of expertise. And in theirs, they have just agreed to it, but they've made no comments.
Yeah.
My question is, just getting to that, which is point 23, does that protect the port for economic growth and benefits, or are we restricting possible new tenants, or 10% to me seems very small.
Yeah.
But
the 10% is for existing sites. So if you're having a new operation come on board, then that's a consenting process, which we've spoken to previously. So it's purely about dealing with additional volume there. And I was surprised the oil companies didn't raise that, but they're probably happy with going through the consenting process. As long as it's a clean process, then it's fine.
Mr. Cooper, I'm referring to your paragraph 21, where you talk about additional fuel storage. How certain or uncertain is that additional fuel storage at ports? How certain that it will be needed, considering that petroleum use is likely to be considered a sunset industry?
I think if you look at short-term, medium-term versus long-term strategy, our view is that if you look long-term, There's always going to be a requirement for petroleum, but it's probably going to stagnate rather than get less. In the short term, the issue is not about the volume of usage, it's about getting the product here in the first place. So from a global stability point of view, if we can't get fuel vessels to New Zealand in a timely manner, then we want additional volume to see us through that. I'm not necessarily talking about greater volume of petrol or petroleum products being used. It's just that we need that additional storage.
The amount to service what's already currently there.
Yeah,
Is that what you mean?
In an unstable global economy where, fuel vessels are just not getting here for whatever reason, and that could be geopolitical, it could be all sorts of things, then we need to have additional storage because the next ship might be 15 days away.
Yeah.
And currently we're talking of probably 16 days storage average in New Zealand. When you take in the peak demand, when people realise petrol's short, that's not a lot.
No.
So,
No,
yeah.
thank you. That answers it well.
And I have no additional questions. Thank you very much for your evidence.
Thank you.
Thank you. I've prepared a summary of my evidence, which I believe has been distributed to you. Good, thank you. I'll just skip through to paragraph 4. So for the reasons set out in my statement of primary evidence, and as partly touched on by Mr. Karen Sayer, I consider it's not appropriate for the Contaminated Land chapter to contain provisions protecting Indigenous biodiversity, as sought by Forest and Bird. I support amending Objective HS02 to include reference to increased scale or intensity of sensitive activities. Clause 3 of HSP1 should explicitly exclude the port zone, and that the clause as it's currently written is potentially confusing and would benefit from being rewritten in its entirety. I agree with the oil companies that Clause 4 of that same policy, addressing natural hazards in respect of MHF, should become a separate policy, and I note Mr. Willis now agrees with that also. I support the recommended changes recommended by Mr. Willis to HSP4 and HSR1, and this is in regard to the sensitive locations versus sensitive environments, so as to narrow the range of areas to be considered in the hazardous substances chapter. However, I do consider that the sensitive locations definition requires further amendment. I comment further on HSR1 and the sensitive locations definition shortly. I support amending HSR2 to enable upgrade, addition and alterations to existing MHF. I consider the heading of HSR4 needs amendment, and I note that Mr. Willis is now in agreement with that, so that's just to clarify they apply to MHF. I have no issues with the recommended changes in the Section 42A report to the definition of facility, and I support the proposed amendments to the planning maps to clarify the location of the MHFs within the port zone. So in regards Rule HSR1, Mr. Trevere and Ms. Westerby seek, this is the underground fuel service, underground fuel tanks at service stations. I don't have any particular expertise in this area. It seemed to me that temporary inundation would not be a major issue, but so I don't have any real issue with what's been proposed in terms of what Mr. Willis has agreed to. Beyond that, it's really beyond my expertise to be commenting, so I'm staying out of that. I'm staying out of that argument. In regard to the definition of sensitive locations and the wetlands riparian margins, I have no objections in principle to what is being sought there either. So turning with regard to Clause 3 of Policy 1 and Clause 4 and the definition of sensitive environments, Mr. Willis's summary indicates he's not yet formed a view on the extent to which it's appropriate to exclude the port zone. in particular in around high hazard. So to summarise, and I think this really reflects what Mr Karansaye has just said to you also, my view remains that there is a clear functional and operational requirement for MHF and hazardous facilities to be in the port zone. Mr Cooper has just outlined that. There are strict non-RMA regulations governing their establishment and management of such facilities. I do not profess to be particularly familiar with them, but I know they exist. New MHF and any additions greater than 10% require resource consent as a discretionary activity. I agree that consenting pathways and the activity status are appropriate in the port zone. Objective HS01 and Policy HSP1, as well as the definition of sensitive locations proposed in the Section 42A report, collectively state that MHF are to be avoided in the port zone in their current state. In high hazard areas within the port zone. There is no certainty as to how high hazard will be defined in relation to the port zone at present, pending hearing F. If the regional policy statement definition were adopted, for example, which is what Environment Canterbury bluntly seeks in their submission, the entirety of the port zone would be high hazard because it's all under the sea inundation overlay. Under this scenario, the Timaru District Plan would in effect be seeking on a policy basis to avoid MHF in the port zone, which, as Mr Karansaye said, just contradicts what the consenting framework provides for. So the amendments that I've recommended to Policy HSP1 and the definition of sensitive locations are not intended to be permissive of MHF, but they are intended to allow MHF to be considered and consented, including in the high hazard areas of the zone. Thank you.
Thank you for that, Ms Seaton. Questions?
Thank you, Ms Seaton. In respect of HSR1 and Mr Willis's recommended replacement of the sensitive environments to sensitive locations, so in your initial, I'm just thinking through what you sought in your initial relief, and then in response to that, Mr Willis introduced this new definition, which has kind of taken a new definition, a new direction, which you've now commented on in your amended relief. Is there a, looking at HSR1 as notified, is there a simpler way to exempt the ports within that drafting, rather than going through, like, I'm thinking about the utility of that new sensitive location. If you're now asking for an exemption of the sensitive location definition, has that kind of added a layer of extra complexity? Or is there something I'm not seeing in... So I can see that permitted 2 would apply if it was the case that you could exempt the ports from HSR1, you'd still need to sort through the flood assessment, but would a potential solution be to exempt ports under the permitted 1 activity condition there?
Explicitly in per 1, you mean?
Yeah.
Yes, that would be a possible solution. It would achieve the same outcome.
It would achieve, that's my long-winded way of asking. Would that achieve the same?
Yes, it would. Yeah, there's different ways of slicing and dicing it. And
Yes.
that would same outcome.
Yes, okay. Thank you. That's the extent of my questions.
Ms Seaton, just not getting ahead of ourselves, we've got hearing F to come, but in the context of hearing F for the port zone, and you, apologies for not being front of mind, but is the port essentially looking to have a self-contained set of provisions for the port? And so in terms of these provisions in the plan, is there going to be an argument put to us at a later hearing that in fact all of the regulation of port, of the activities related to the port that have a functional need to be located in the port zone are contained in one section of the plan? So are we duplicating effort here by tweaking a set of provisions that have across the district application?
Yes, potentially. I think it's not...
Should we be thinking that actually it's more efficient or effective to actually address them in a different part of the plan? Or is there still a need to ensure that these provisions account for and address appropriately the needs of the port?
Yeah, it is tricky. The overlap between these two hearings does make it tricky. The port is looking for certainty that it can get MHF consented in the zone, and it's having to run those arguments without having any certainty as to what is going to pop out in the hearing F. Where the conversations are going at present, because there are a lot of discussions in the background as we try and work with Mr Willis and with ECAN around what these provisions are going to look like, and we have not yet landed that, so I can't give you a certain answer, even from our perspective, but what we are more likely to be seeking is that the port zone is somehow exempt from being a high hazard area. So it's not that there will be new provisions inserted into the port zone chapter that specifically deal with the port zone in MHF, for example, or other hazardous facilities. What it will be is how we address what is a high hazard area and how that relates to the port. So in an ideal world, when we hit hearing F, the port will no longer be affected by the provisions or constrained by the provisions around high hazard, but we've not yet landed on what that will look like. So yes, we may be duplicating effort here. We've just gone a little bit belts and braces because we don't know exactly what's coming, or even whether you will agree with where we land.
Yeah, so you're addressing each of the options as they arise in the context of the...
Yes, and it may well be come hearing F, and when you as a panel make your decisions, that you decide actually, yes, the port can be exempt, across the board from these hazard provisions. It doesn't work, it's an unusual area, and then we can go back and actually you don't need these exclusions in the hazardous substances chapter because they just don't apply anymore. So I fully expect you will need to revisit some of these provisions come hearing F. Yeah. But until we know for sure that the port is somehow exempt from the high hazard provisions, at the moment it is getting caught by these provisions and they won't work.
We might just, need to think that through in terms of the next stages of hearings and whether we provide, I'm just thinking aloud, whether there's an opportunity to sort of come back essentially and get you in a room having got all the ducks in a row. The 42A officers will do interim replies as we go, and then they will have an opportunity to reply in the end, but it's just how we ensure that there's an opportunity for you to have joined the dots as well. Yeah. That, perhaps I might just leave that as an issue that we need to address. It won't be the only submitter that arises as well, because there's lots of people that are appearing multiple times and coming to us with interrelated issues as well. So Mr Willis might be something you need to give some thought to as well as to how best to manage your reply in that context.
I just have a follow-up question on that.
Sure.
So when I've looked at the port zone, I've looked at port activity, which is permitted. It expressly excludes major hazard facilities. So then it would fall into this hearing, wouldn't it? Unless there's going to be some changes to the definition of what
the definition
port
of
activity is.
Port activity, I have not looked at that recently, so I'll take your word on that. It explicitly excludes major hazard facilities,
yes,
does it?
Okay, it does expressly exclude.
Obviously, we intended in that case that it would hook through into the normal consenting processes.
Right.
Yeah. It was never intended that MHF would be permitted in the zone. Right from the start, we've agreed that would not be appropriate.
Okay, thank you.
Any further questions
Thank you.
on that? But thank you. Thank you, Mr Karansaye. Is there anything else you wanted to add or comment on? In terms
Nothing
of
more,
process or-
thank you, Ma'am.
Thank you. That brings us, or near the end, just the process from here, we'll just catch up with Ms Vella and the council team. You're welcome to stay, you don't have to leave. Then we'll have a closing karakia and wrap up hearing D. Thank you.
Thank you, Madam Chair. After being mercilessly mocked by my teammates yesterday for not being quite so organised with my homework list as I thought I was, I've got a snappy list for you today. Perhaps if I could just cover off a couple of things orally from yesterday. The first one relates to Mr. Willis's report. There was an extra footnote to the definition of unacceptable risk in Appendix A, and he's confirmed that's not required. So that can be deleted. And you also asked me to confirm with Ms. Pfluger whether the rock wear had been taken into account when assessing the ONL. So she's advised me that the rock wear itself is in the VAL and the ONL stops just before the rock wear. Yeah, but that the location of the rock wear has been taken into account, and in fact that's appropriate that it's outside the ONL. In terms of homework from today, we've got from Mr. Boys is to produce a comparison table between the PDP and the ODP in relation to the South Rangitata Reserve rules. And that's alongside the 3 questions that he had to answer from yesterday. Mr. Willis, I think he's just got to work with the oil companies in port on some of the drafting, particularly around contaminated land. And for Ms. White, she's going to do some work with the ECAN consent planners and Mr. Hole for Rooney in relation to the gap analysis for the gravel extraction in riverbeds. And she has a slightly long list from yesterday as well. And I'm just wondering whether that's all I've got on my list, and just wondering whether it would be helpful for me to collate yesterday's and today's homework together and send it to the panel so there's a complete list. If that would be helpful, I'm happy to do that. Okay, thank you. And then just to, we need to talk about some timeframes for interim reply. But just before I do that, I just wanted to remind the panel too that there's a couple of outstanding matters from hearing B that we're still working on, and that's the small fixed-wing aircraft. I think we've suggested that we'll come back with a report on the 6th of December on that. And there's also some ongoing discussions with Kiwi Rail around the setback, and that we're still working on those. We don't have a particular date that we were going to report back to you on, but perhaps we could do it either at the same time as the reply. Might be a good way of wrapping everything up together. So I think that brings me to timeframes. Our hearing E reports are due on the 10th of December, and the feedback that I'm getting is that it would be very helpful to not have to do the reply before those reports are finalised, but there's another week in the year, and so we could perhaps have the replies complete by the 18th or 19th of December, if that would be acceptable to the panel. Thanks. That's all that's on my list, yep.
With regard to Mr. Hall's presentation today for the South Rangitata Reserve, he was able to confirm the site to which the zone request change related to. So it would be useful for Mr. Boys to revisit his recommendation to see if he needs to assess anything different or arrive at a different revised recommendation. It may not result in any change, but it would be interesting just to cover that off. Thank you.
Thank you very much for your assistance for the hearing process, Ms. Villa, and the Section 40, Mr. Willis, and our thanks also to Mr. Boys and Ms. White also, and to all of submitters for participating in this process. Thank you, and we look forward to seeing you again in the new year. But for now, we'll close with karakia. Thank you.
Unihia, tapau, kia wātia, ai, kua wātia.
Kia ora. Tēnā koe.